the channel where the dough don't rise. Broken bakers here with the sarcastic eyes. From Danish pastries to courtroom crime, where the spelling's a mess, but the humor's prime. Proceed defendants taking the stand, with wine moms laughing, glass in hand. Mods like Marissa and Valhalla too. Irish and whiskey keep the chat in view. It's trial tribulations with a sprinkle of wit. Chats popping off, yeah, they never quit. Jamie's got the deals and the beauty hacks. Dollar store glam keeping us on track. So come for the crime, stay for the snark. Broken bakers baking up a legal spark. Mo hops in with spicy takes. Jemima's got the docs, Farrell brings the shakes. Brandon keeps it wild, Iron Rabbit keeps it chill. Together they're the dream team, streaming the thrill. With courtroom chaos and dry witty flair, we're roasting defendants, cause life's not fair. Grab your wine, your snacks and settle in. Chat's the real star, let the fun begin. It's trials, tribulations with a sprinkle of wit. Chats popping off, yeah, they never quit. Jamie's got the deals and the beauty hacks. Dollar store glam keeping us on track. So come for the crime, stay for the snark. Broken bakers baking up a legal spark. Broken baker streaming, so don't you miss, where courtrooms and sarcasm meet Danish bliss. Mods and chat, we're keeping it clever. True crime and dry humor now and forever.
Hey everyone, starting a little early because court started half an hour early, so we will be a little behind, but talking about small behinds. Hey Jamie.
Yeah, sure. Morning. Hi everybody.
For those of you who weren't here yesterday, and for Glow that asked this morning for my morning stream if I was going to cover this trial, yes, we will be covering this trial. I hope the audio is better, and before anyone starts asking, there's no CC available, but let's do it to it, as they say, the young kids on the streets. The streets I used to be on when I was a gang member.
Oh Lord, big curry yellow.
Hey Helen. Hey broken hearted.
Were in Davidson County on the 8th and the 9th of last week to choose a jury. Mr. Chen had been transported on January 6th to the Davidson County Jail. Jury selection began promptly on the 8th and ended in the late afternoon of the 9th. The court did inform the parties that court would be closed on January the 10th due to inclement weather. Friday, January the 10th, all parties, including Mr. Chen, were back in Hamilton County. And at approximately 2:15, the state received notice from Mr. Weiss, the defendant's attorney, that they were giving notice to the state that they intended to introduce expert testimony regarding the defendant's mental condition, presumably at the time of the offense in 2022. Of course, this caused concern for the state for many reasons, primarily the timeliness and the violation of Rule 12.2b in terms of notice of a defendant's mental condition. The state asked for a phone conversation with all parties on Friday based on that concern and, quite frankly, just confusion, as this had not ever come up in any type of hearing or discovery or meeting with the parties. It is significant to note that Mr. Moyle and I, General Moyle and I, have met with Ms. Morris and Mr. Weiss multiple times throughout the last several months to exchange even undiscoverable evidence. The state has gone out of its way to provide demonstrable exhibits, PowerPoints. We allowed them to look through our own box account. We've had several met them at the police department to review evidence. Never has an expert witness been mentioned. And the defendant's notice did not provide any information as to what mental condition was being alleged or asserted by their expert. the court then ordered informally on that phone call that the defendant basically turn over what was in their possession in regards to the mental condition and any information about the expert. Mind you, the name of the expert was not listed in the notice that was filed at 2:15 on a snow day. And on Friday, later in the day, Mr. Weiss did send a email to General Moyle and I with the expert's name and his curriculum vitae. And I believe in that email, it was also notice. It was a letter that signified that while the expert was not licensed as a psychologist in the state of Tennessee, he had received temporary licensing for January the 7th, 2025. That letter was written by the state of Tennessee, 2024. It was not until approximately 5:30 on Saturday that the state received what is entitled memorandum.
Thank you for the notice, Brandon. I have boosted the audio. I have turned the audio up. This lady has the normal microphone anxiety, and I've watched all the hearings. It's always a super low courtroom. I will say, though, on Lawn and Crim, the audio is probably 50% higher than it is on the local TV station, because that's just... So I've done all the stuffings I can do. Hey, Texas.
Pertaining to expert testimony. In that memorandum, the psychologist kindly explains in our
that what friends are for, annoying, berating, always treat you condescending. That what friends are for. Thank you, Brandon, for being a friend.
Articulates the law to this criminal court, of which 4 attorneys involved in this case and a criminal court judge are acutely aware. And there's one paragraph in that alleged expert's report that has to do with Jason Chen. There is one sentence in that report that states that Mr. Chen was not able.
I'm not going to put out a conspiracy. All of these prosecutors and lawyers have seen how big trial streaming has become. And now they just say, F you, we will constantly go away from the microphone just to annoy everyone.
Possibly.
Me too.
That Mr. Chen was unlikely to have possessed the requisite premeditation for the act of criminal homicide. The memorandum never mentions a mental condition. As it stands right this second, the day of trial.
Hell, Mr. Chen is accused of stabulating his girlfriend, I believe 60 or 80 times, putting her in a suitcase, dumping her by a river.
The state has no idea what mental condition the defendant is alleging he had on November 23rd, 2022. We don't know if it's an intellectual disability based on the tests that were apparently administered to the defendant, which are attached to the expert's memorandum. Based on those, it would indicate it was some type of intellectual disability, as those are psychological examinations that go to reasoning and critical thinking. We have no idea if it's a mental health disorder such as schizophrenia or bipolar. We had heard on the phone call with Your Honor the words voluntary intoxication. Voluntary intoxication, the word intoxication, the word substance abuse, the word addiction is never in the alleged expert's memorandum. This is the epitome of unfairness, Judge. The state has the right to present rebuttal proof. one of the reasons why Rule 12.2 has a timing subsection to it. There is no.
Okay, there's a few new people coming in. This is pre-trial. The jury hasn't arrived yet. That's why we started a bit early. They are doing motions because, according to this lady, Saturday, they were given a new notice that they will provide some sort of expert testimony alleging a mental health defense. And she is complaining that they didn't have it with adequate time to call a rebuttal witness. So they are probably trying to suppress that expert testimony. That is what I gathered so far. Yeah, sorry, we started a bit early because they're doing pretrial motions. No, it's pretrial motions. So opening hasn't started yet, no. Well, yeah, sorry.
No way. It is not virtually impossible. It is absolutely impossible that the state ever could have searched for or investigated any type of rebuttal proof for an expert that we not only knew, well, we didn't know of, but we still, as of 9:30 on January 13th, have no idea what the expert is going to allege.
No, this is in Tennessee. Danish courts are not televised. And we don't speak English that much in Denmark.
Or opine at trial. We were not able to voir dire jurors on whatever mental condition this expert is going to allege existed on November 23rd, 2022. In fact, if the jury was sitting in the box right now for voir dire, we would have no idea what to voir dire the jury on. We have the right to a fair voir dire. We would have, in fact, asked questions that pertained to some mental disorder, I don't know, still don't know, mental condition, mental health issue. I have no idea, intellectual disability, no clue. We would have, in fact, voir dired on that issue. It would have changed the process of voir dire for us. It would have changed the preparation for trial for the state of Tennessee. Had we known that there was any type of expert witness that has to do with psychology or the defendant's mental condition, we would have an expert witness sitting in the audience right now to hear what this expert has to say if the court allows the expert to testify this morning in any type of deposition or hearing. We would have them here. We weren't able to do that for obvious reasons. We learned the expert's name at the end of the day on Friday the 10th. Saturday and Sunday are not working business days. While the state of Tennessee worked all weekend, a psychologist or psychiatrist in Chattanooga, we couldn't get a hold of them. And while
pre-trial motions, they dumped a possible mental health defense. They don't know what the mental health defense is, but they were informed Saturday at around noon after they seated the jury last week. Then they were dumped a mental health type of defense. They don't know anything about what the defense will be or what he will testify to. That's why they are arguing that shouldn't be allowed in, because they haven't been able to voir dire the jury based on it. For those of you who don't know, when they do the jury selection, if, for instance, you are going with something related to schizophrenia, you would ask a jury, do you know anyone or do you suffer from schizophrenia? So they kind of know. They can say, oh, I don't like that juror because they have a bias. But they weren't given that option because they got it dumped in their lap Saturday at noon. Remember, the jury has been picked up in Nashville and moved to Chattanooga because they didn't believe they could get a fair trial in Chattanooga. So they have bussed in a jury that will be staying in Chattanooga for what is potentially a 10-day trial. So doing tricks like this will probably not make them like each other more.
Nah.
Maybe I need a banner. A banner for what? What the trial is or what's happening?
Probably what's happening. I don't know.
It's
No one
I
seems to
don't.
read it ever anyway. But yeah.
Yeah. I don't know if they are sequestered, but it's because they are bussed in from a different city. So that's why they're staying at a hotel. Let's see how he rules. Yeah, Banner, what's happening? Marissa and Brandon is really jumping at my heels today.
No party in this courthouse should ever underestimate the capabilities of the state of Tennessee. We are not magicians. We can't just come up with a rebuttal expert witness on a mental condition that we are unaware of at 9:30 on January the 13th. This notice was untimely. This notice never would have been able to happen in any other case in your honor's court except for a sequestered case done in the manner in which it was done in this case. Your honor knows, typically, in all of the trials that the court has not only had as a criminal court trial judge, but also as a prosecutor and defense attorney, normally we move straight from jury selection into the state's case in chief. Typically, this would never have even been able to happen, much less allowed. It is in a rare circumstance that Mr. Weiss could have planned to know of an expert in early December. We know that they knew of him on December 7th.
Jamie, do you know what I think I should do? Instead of having
What?
the little baker man down here, I should make a P and a D. No, Lefty, not that kind of D. So people can say, oh, prosecution, defense. Because it's always one of those questions. And I will forget to switch it, and then everyone will get mad at me. And
Yeah.
the rest of the world.
I feel like people are going to go, what does the P or D mean?
Because based on an email that they sent to us, it states that he confirmed his availability to meet with the defendant on December 7th. 1 month before he met with the defendant in the Davidson County Jail. They waited. They waited. They knew the week before jury selection that he was going to interview the defendant in the Davidson County Jail. They knew that he had interviewed the defendant in the Davidson County Jail on the 7th. They were in court with your honor on the 8th and the 9th. The court repeatedly asked the parties, is there anything that needs to be taken up? Repeatedly. At the end of the day on the 9th. But it was not until 2:15 on January the 10th, after 2 years of preparation on this case, that the defense came up with a mental condition defense. And the defense has argued that it was only after the state provided a demonstrable exhibit to them that they realized that they needed an expert witness that had to do with the defendant's mental condition that affected his ability to form premeditation. Think about this, Judge. Premeditation has been an element in this case since 2022. The Hamilton County Grand Jury indicted Mr. Chen for first-degree premeditated murder. If defense attorneys believed that his mental condition at the time affected his ability to form premeditation, and they waited until January 7th to have an expert evaluate him, then we've got much bigger problems than a timeliness issue. Premeditation has been the case. It has been an element in this case since 2022. And notably, Mr. Weiss represented Mr. Chen in 2022. There has been no counsel substituted. It has been Mr. Weiss since the beginning.
I love that I know a
The
state
demonstrative exhibit
Marissa
that
doesn't.
the defense has such a problem with, as the court has already seen, involves two pieces of evidence that have been in the defendant's possession for almost 2 years. A photo from Mr. Chen's apartment of carpet with blood on it, and a photo of Jasmine Pace from the medical examiner's office. The court found in the hearing on this issue that even the state could have superimposed this piece of evidence on this piece of evidence to come up with a demonstrative exhibit. How can a demonstrative exhibit that was given to the parties on December 11th, the day that it was given to the state, even though every party had both photos, but the superimposed photo was given on December the 11th, how is it that that photo affected premeditation in so much as the defense all of a sudden, near or around December 7th, contacted an expert witness? It is untimely, it is unfair, and the state of Tennessee has a right to a fair trial. And the people of the state of Tennessee have a right to a fair trial. We ask the court to exclude any expert testimony at this point in time that was presented to the court and to the state in an untimely fashion, especially that of Mr. Douglas Lewis.
Or in Mr. Weiss's pleadings, he mentioned that the demonstrative exhibit seemed to indicate that the victim might have been handcuffed in Mr. Chen's apartment. That's one thing I think.
And sadly, that is the judge and the audio of the judge. I hope they'll fix it, but I can't promise they'll do it. And I'm not sure if we've seen this judge before, but I think we have seen, or we were supposed to have, wasn't the case with the bikers who pew-pewed 5 people supposed to be with this guy? I think so. So, but I hope the audio will improve. It's all we can do. If it's gonna be guess what they're saying, we might switch to the rose petal case or something, because no one is served if we just have to sit and guess what they're talking about. The rose petal case is seating the jury today, not it hasn't started today. I know a lot of people have asked about it. And yes, I do have the state flag of Tennessee, because even though Tennesseans don't like Danish people, they won't serve me beer. I do like Tennessee, and I got it from the White Rabbit.
You mentioned this problem with the demonstrative exhibit. Could you respond to that?
Sure. Your Honor, the medical examiner issued an autopsy report. The date of examination is 12/1/2022. The autopsy report was given to the parties just within a month or two. Of course, it takes the medical examiner a month or two to finalize an autopsy report. And in that autopsy report, there's a sentence that says, the injury locations are consistent with the decedent's fetal body positioning as found.
They cannot say for sure that the victim's handcuffed while alive in the apartment. I heard you right. The medical examiner's report indicates that the blows might have been received also from fetal position, but not necessarily handcuffed. Is that correct?
I believe that Dr. Cogswell can opine in what position she would have been in when the injuries occurred, and then the jury can therefore, as the trier of fact, make their own conclusions as to the position of her body was only in the fetal position with those type of stab wounds because she had been handcuffed. So the trier of fact can draw their own conclusions, but
this case is going to be interesting. She was cuffed and stabulated Oh, it might be better. I hope the audio works because this sounds like a very interesting case.
But furthermore, Your Honor, there was a bond hearing in this case in General Sessions Court in which Mr. Weiss represented Mr. Chen, and similar to the autopsy report, Dr. Cogswell testifies the injuries and the concentration are all on the right side. Virtually all of them can be inflicted with her in that bound position. So I believe that there is evidence in the record that would allow Dr. Cogswell to testify that she was in the fetal position. Whether or not he is going to testify that she was, in fact, in those handcuffs, that is for cross-examination. You can obviously cross-examine. That is part of the trial experience. So the defense did have information and evidence and discovery for years.
But I haven't seen that they are seeking the DP in this case. I think, didn't Tennessee do something with the DP a couple of years ago? I think we talked about it in another case that there was some ruling on it. I'm not sure. But this isn't, it's only a lifer.
That would have indicated that she was in the fetal position. She was in that fetal position because she'd been handcuffed, and the jury, as a trier of fact, can find that.
Good morning, John. Let's be clear. Rule 12.2B2 says timing. Notice described in 12.2B1 shall be filed within the time provided for filing of pretrial motions or at such later time as the court may direct. The timing to file pretrial motions has not ended. As of right now, without a jury sworn, I could file a pretrial motion right here, right now. This rule does not limit my ability to file a notice right here, right now. This court, and I say this with the utmost respect, could have ordered a scheduling order or a docketing order requiring the parties to have provided certain proofs, certain discoveries, certain evidence, certain motions at this point. The court has never ordered that.
Worse audio before.
The defense is not in violation of the Tennessee Rules of Criminal Procedure, and the defense is in violation of any of the court's orders. So this is not untimely. It is timely. Secondly, Dr. Lewis was contacted about a month ago due to timing of the holidays and him getting authorized practice.
Yeah, it sounds like, thank you for, it looks like they have better audio on this one. And then a booster, and
all the attorneys texted the court. We had a conversation about it. And the court has ordered that Dr. Lewis submit a memorandum or report, which he did on Saturday. And I don't know what document the state is reading, but the memorandum in the submitted by Dr. Lewis talks about the psychological issue, diminished capacity. It's right there. We're not alleging that Jason was insane. The state did request a notice for the insanity defense. We're not pleading insanity. So that has no bearing here. We're not saying that he has some type of mental condition. He's not have any type of mental health condition other than what's stated in here. So it is very clear the state has exact notes of what's being alleged by Dr. Lewis. And even if they don't, Dr. Lewis has been ordered to be deposed this morning. He is ready and waiting in the virtual waiting room for the court to admit his testimony. And finally, I find it rich that the state says this is untimely. This court, again, didn't file a scheduling order. That means Rule 16 discovery applies up until the day of. I was given a video from Walgreens that I had never seen before. And when did I receive this video from the state? January the 9th. I'm sorry, January the 8th. The state has provided discovery monumental amount of important discovery in the last 45 days. At no point did this defense seek a continuance for providing this discovery. The state hasn't sought, or the defense hasn't sought to exclude the discovery based on Rule 16 violations because there isn't one. There isn't a court order. It really wasn't until the defense met with the state and we saw the theme and theory of their case. The state is asking you to read between the lines of an autopsy report. But General Moyle said at the last hearing and in his own response to this notice that they are going to allege that Jasmine was shackled while alive and then killed. That is nowhere contained in any discovery, any evidence. We are surprised. We are being ambushed with this same information. And once it came to the realization that they're providing this information to prove their theme, well, then it became necessary to show that Jason doesn't have or has a condition that would prevent it or negated premeditation. And that's what Dr. Lewis's testimony is all about. There is nothing preventing him from testifying at trial. The state is not prejudiced. They will have full opportunity to depose him. They'll have a full opportunity to voir dire him during trial, and they'll have a full opportunity to cross-examine him during the course of the trial. It's not unfair, and we ask that the court deny their motion to exclude Dr. Lewis. Of course, Judge.
Totally easy. The Walgreens video that you provided recently, in any way unfairly prejudicial to your case, to the delivery that you're asking for consent?
No.
I don't like filing schedule order. I know when I was practicing that a lot of work does get done as it builds up a trial, and so therefore a lot of things have to happen. As long as everyone communicates, I've never had it be a problem. I don't even know if it's a problem today. We're certainly discussing it. But the file 12.2, as everyone knows, doesn't necessarily put a specific timeline on it except before trial. This is something that apparently the advisory committee's looked at a lot. In the notes, it's in the case law, it repeatedly refers to unfair surprise. But the state is unfairly surprised. So apparently it's a common practice or common occurrence, I should say, that a lot of times these experts all brought up at the last part of the trial prep. And so that's why there's a lot of case law. And so in this particular case, I'm clear when you ask for funds for the expert in December, it was a wide mood, kind of expert can help you out with this, helping you cross-examination, or just looking at the case and helping you think different angles for sure. It seems like it got rushed at some point, and it's almost like when the state allowed or was allowed to use the demonstrative exhibit, that solidified or caused you to need the service that this expert has provided you so far. There's thinking your own notion kind of encapsulates it. We're going to talk about it once the defense attorney, as a defense attorney, you promptly secured an expert issue for the length for that is state discloses the last minute evidence for premeditation. That's the month before, despite the case being 2 years. Upon receiving this late disclosure, the defense promptly secured an expert issue for. So that's how I'm interpreting that. Is the acceleration came from the hearings in December where we talk about the exhibits and the ones that deemed to be admissible. Is that a fair assessment?
Yes, sir.
Okay. Thank you.
Your Honor, may I briefly respond to some of that timeline? The defense states that it was only once they learned the theme and theory of the state's theme and theory that they realized that the state was going to allege that she.
Hearing her talk now compared to before, and then you can really tell how low the judge's audio is.
Shackled at the time the injuries occurred. But that timeline actually doesn't work in terms of the timeline of their expert witness, because the meeting that we had with them in which we discussed and went over the demonstrative exhibit was December 13th. The day that they got that demonstrative exhibit was December 11th. Based on email communication and the representation of defense counsel, they confirmed Dr. Lewis's availability on December 7th.
Can I, on that, Rick, please be sure?
Yes, Your Honor. Yes, Your Honor.
There are many reasons to retain an expert. When Mr. Wise approached me on it, I wasn't sure exactly how this expert could be used. It might be just for consultation, it might be for sitting in court for cross-examination. And so I don't really hold that against Mr. Wise as far as retaining an expert. It seems that the purpose for which this expert being offered now seems to be accelerated with the demonstrative exhibit. That's not my interpretation, but if you want to respond to that.
Well, that goes against what the defense just represented on the record, though, Your Honor. They're saying that this expert became significant after they saw the demonstrative exhibit and also realized the theme and theory of the state, which, by the way, they are not entitled to, which shows how transparent the state has been. That the defense is not entitled to our theme or theory until opening statement, of course. But in Mr. Weiss's motion, he states this assertion necessitated the defense's consultation with an expert witness to address and analyze the state's claims concerning the photographs purportedly depicted. That's not true. The expert confirmed his availability to meet with the defendant on December 7th. The timeline doesn't make sense. Another note, Your Honor, the court was on the phone on Friday. The court asked Mr. Weiss if he could describe the mental condition just so that the parties could know. He says voluntary intoxication. This morning it's diminished capacity, which is not a mental condition. It's a legal conclusion. So he actually put us on notice of voluntary intoxication, which is not the mental condition. Again, unfairness. The state is now more confused. Diminished capacity because he was intoxicated. Well, that's voluntary intoxication, which is not mentioned in the expert's memorandum. Again, more confusion. And let me add, Your Honor, it's not just that the state will need to, over the next 2 weeks, while General Moyle and I are proving Mr. Chen guilty to a jury of 12, it's not just that we need to secure a rebuttal expert, but we also have to subpoena records. We would be interested in all types of records of the defendant if he's claiming diminished capacity on November 23rd, 2022. We're going to be interested in new witnesses. Witnesses that maybe he was communicating with. Witnesses that may know about his capacity on or around November 23rd. This requires the state to do more. And General Moyle and I don't have time. That's the point of Rule 12.2 and every other rule that requires timely notice, Judge. That is the point. Any questions, Judge?
One thing that comes to mind, I wanted to ask about earlier, on the expert report itself.
She annoys me already.
You don't like her?
Listen, this is just her, the way she speaks right now. She might turn her around for me.
I love that Jamie hates people within 15 minutes.
Well, it's always your first impression, and then sometimes it can change.
Yeah. Well, I didn't like that she said, any questions, Your Honor?
Yeah, that's what got me. I was like, wait a second, ma'am.
Imagine Marissa liking a boss lady.
Yeah, it's fine.
Surprise of the year.
The bold, I guess, conclusion of what he testified to. I concluded to a reasonable degree of psychological certainty that it's highly unlikely that Mr. Chen possessed the requisite premeditation to be active in a homicide. I assume that that is a central aspect of his testimony. He'll elaborate on that, but it would be that.
Yes, sir.
Okay. So my question is that it says highly unlikely, which introduces an amount of speculation about this particular. It's not conclusive. I'm not saying the state has to agree to it, but it seems that highly unlikely is subjective, that is cutting to the Daniel factors. I don't know whether that would be substantially helpful to try our facts, to introduce a speculative opinion that it's highly unlikely, instead of he's concluded that Mr. Chen did not possess the requisite premeditation. Could you respond to that?
Yes. I don't think forensic psychology is not an exact science. We even give leeway to exact sciences. This court deals with BACs all the time, and BACs are 99.7% effective. It's not 100%. So there is no type of empirical way that a forensic psychologist could say with absolute certainty that this did or didn't happen, or this person or didn't have this mental condition. They can only base it on a number of factors. I would show the court that in the last part of the memorandum, you can see the testing that Dr. Lewis conducted, and that testing shows which are standardized testing, shows the base raw scores from where he gets his opinion from. I think the question that the court asks is a very good question, but it's better directed towards Dr. Lewis.
Looking at this, if I understand, and looking at page 6, it says a single standard score to a reading index
Patty B.
measure having a mean of 100. Understanding this correctly, Mr. Chen scored a 94. Seems pretty close to me. I don't know how much that would have impacted his decision. Maybe it's just a test that gives everyone. The other scores to be able to test the trauma symptom inventory looks like based upon self-report, where the person taking the test is asked how often each symptom happened in the past 6 months when Mr. Chen was incarcerated. So I'm not sure how helpful to a jury would be to have these scores. Someone who's obviously been incarcerated for a long time.
I asked Dr. Lewis, that's a very interesting set of questions. I asked Dr. Lewis about that. I said, well, wouldn't have the evaluation been more, better, effective, more closer to the event than now? And he actually said, no, that's not the case. It gives after time and reflection, and gives them the ability to answer, I guess, more honestly. But again, that's a better question directed towards Dr. Lewis. Thanks.
As I understand it, they are going for a willful intoxication defense, but that's not a defense because it's
No.
willful.
I don't know how you're gonna get around that.
Yeah, that's stupid if they're gonna say, well, he just stabulated her 16 times because he was in the White Claws. And white claw, no law. That's the rule, Your
No
Honor.
laws. Yeah, no laws with those claws.
That doesn't make sense. You can't use intoxication as a defense. It's the same with a DUI. You can't say, I really shouldn't have been driving when I rode through that parade. I was drunk, Your Honor, but it was a Friday. You know how it goes.
Yeah.
That's not a defense.
No.
A defense against first degree and bumping it down to second? No, it's a willful intoxication. Willful means you chose to do it. So you should have figured out the consequences of you doing it. I don't know. I don't know what it's... Oh, get under a hot blanket there, Iron Rabbit. No, I don't... I don't think so.
Anything else from the state?
No, Your Honor.
Look for the court on this particular motion by the state to exclude the expert as the record reflects. There was an effort by Mr. Weiss to secure an expert to file Weiss. And
Yeah, but there's a big difference between stabulating someone 60 times and driving a car and hitting someone under the influence.
everyone agrees that this particular expert's testimony in this report was generated from the court's ruling about allowing a demonstrative piece of evidence. And so, looking at it in that lens, we did pick a jury, and I'll start by saying this: while we're picking a jury, I noticed was mentioned that I don't see this as unethical. I don't see it as something that Mr. Weiss waited until the last minute and orchestrated this from day one. It does feel very rushed. Again, this evaluation happened on Tuesday, less than a week ago. The state points out that they did not get the voir dire on a mental condition because they didn't know. Our Friday phone conversation involved diminished capacity. Put on record, we talked about whether it's insanity or not. And Mr. Weiss said it wasn't insanity, so that leaves only a few things. Diminished capacity was something that was mentioned, as well as voluntary intoxication. The report doesn't mention voluntary intoxication. Again, the highly likely seems speculative to me. So I interpret all this using a greater overall analysis as it just seems very hurried, which makes sense. It was something that the state, once they got the demonstrative evidence in, that's when we see this uptick in activity. And so I can conclude fairly that the expert's testimony was based on the defense's stated need to respond to it with this particular expert's testimony. Neither side's asking for a continuance. If this case were to be continued, it would be a huge waste of resources. But the record should reflect that I would do that. If it came down to something that truly would cause either side to not have a fair trial, I would grant a continuance in this case. I don't think that's necessary in this particular event. Again, my interpretation is that Mr. Weiss secured an expert for numerous reasons. In December, when the demonstrative evidence was deemed admissible, that's when things started to coalesce around this particular direction. And so I do think that the demonstrative evidence aspect is key and foundational to why we're here today arguing about this particular expert. So the ruling from the court is that, as talked about, as discussed by defense counsel, conceives that the expert's testimony would be that it would be highly unlikely that Mr. Chen possessed directly premeditation to be active criminal homicide. I don't see that as actually rising to the level of anything that's going to be helpful to this jury. I don't think it introduces speculation. What is highly unlikely? Perhaps he could answer that, but in contrast to the DUI experts or the engineering experts for crash reconstructions, yeah, they have a range, but they can say clearly.
They were set to go at 10, so it's not.
That it happened to where the defendant's speed was within this range. It was not less than this amount or not more than this amount. With DUI, they can speculate it's at least 0.05, but not more than 0.12. In this particular case, I don't think that the expert's testimony is concrete enough to be helpful to the jury. I don't think we
Between 0.0. No, how is it you say it? 0.05 and 0.12. That's not. That's slightly bust.
Yeah.
That's yeah. Rage Chrissy, yes, 10 Eastern.
Need to depose him, or that if that's what his opinion would be. I do think that out of an abundance of precaution, the state's not going to like this part, but out of an abundance of precaution, I'm going to modify my ruling about letting the demonstrative evidence in. The ruling is that the demonstrative evidence cannot come in as an exhibit. The state can certainly use it demonstratively if they wish, let the jury draw the conclusions. And also about the expert in the state's Dr. Cogswell. The defense has been expressed concerns that Dr. Cogswell will provide evidence that says that this was premeditated. I don't think this would have come in, but just for clarity, whenever you're directing Dr. Cogswell, you cannot say, is this indicative of premeditation? That's something that would have been objectionable to anyway. I'm not saying you would, but just where we are today, based on defense attorneys' assertions that the medical examiner's testimony might be unfairly utilized for him to opine that it was premeditated. Obviously, you can't ask anything about that.
Like that he's
Correct, Your Honor. He's a forensic pathologist, not a psychiatrist, psychologist. So that's not still his expertise.
And so based on those factors, let the state's motion to exclude expert testimony be granted.
Your Honor, at this time, I would request to do a proffer and have Dr. Lewis answer some questions.
At this point, I'll let you correct your witness.
So we're gonna do a profit now.
Sounds like it.
Then I'll just do this. KK asked, "Good, your middle name isn't K as well. Then I could get in trouble. Why does the prosecutor keep referring to someone as general, and who is that person, prosecution or defense?" The lady in the maroon jacket is the lead prosecutor. The general is their Tennessee's way of saying district attorney or lead investigator, prosecutor, something. They call them generals down there because I don't know. It's a thing that sticks around. Some people call them district attorneys. Some people call them generals, I think.
Sometimes and not others have some connectivity difficulties. Felix, can you text Sean Johnson? Maybe.
Do you swear or affirm to tell the truth, nothing but the truth, so help you God?
Attorney General.
I do. Which one? He let Felix know we got figured out this day.
Good morning, sir.
Hope your trip went well, Dave.
Good morning, sir. Can you hear me?
Yes, I can.
Okay. Can you please state your name?
I am Dr. Douglas E. Lewis Jr.
And Dr. Lewis, what do you do for a living?
I am a forensic psychologist.
What is a forensic psychologist?
A forensic psychologist is a clinical psychologist who uses psychological principles to answer legal issues.
How long have you been doing that?
I have been in practice solo for about 5 years now.
To become a forensic psychologist, do you have to get an education?
Yes,
You need
so you
something?
have to.
Go ahead.
So you have to earn a graduate degree, in particular a doctorate in psychology. And in order to do that, one must have 4 years of didactic instruction, in addition to 3,000 hours, usually minimum, in practicum experiences, which is hands-on experience under supervision. Then one must
I'm not. His mom was interviewed at one of the hearings, and I think uh, she needed a Chinese interpreter. I'm not sure how what their background is.
go through a match process in order to get a pre-doctoral internship, which is a year-long internship.
I'm gonna skip
And then
through.
you earn the doctorate.
It's just
Once you
I
earn
went to school.
license. So initially, I earned my bachelor's in
5 years.
yes,
And what does your practice,
approximately.
what does your practice entail?
My practice entails both civil and criminal justice cases. So I conduct competency to stand trial evaluation, criminal responsibility or mental status at the time of the offense evaluation, violence risk assessment, psychosexual evaluation, independent medical evaluations, workers' comp evaluations, personal injury evaluations. And that's for both juveniles and adults.
Have you ever worked in the prison system before?
Yes, so I began scanning one, those have.
How many times?
I would say approximately 10 times. I've testified in court.
Is it just criminal cases or different?
22 to 2023.
Are you licensed in Georgia?
I am.
Are you licensed in Tennessee?
I am not licensed in Tennessee. What I got was a temporary authorization to practice psychology through the board in Tennessee.
Thank you, Dr. Lewis. I want to talk a little bit specifically more about this case involving Jason Chen. Do you remember when
Or was recognized as an expert. Would you like to be recognized as an expert?
Yes, sir. At this time, the defense moves to offer Dr. Douglas E. Lewis as an expert in forensic psychology.
State one of audience witness.
Your Honor, this is, as a proffer, the state doesn't have a right to cross-examination. So if this is just simply a proffer,
I'm proceeding if you want to even have him qualify as an expert.
sure, the state would like to argue the witness.
This is to prove that he is an expert that can come in later. It's the same as we saw with Dr. Green and Dr. Russell in the Karen Reed case. But because they were so late filing the expert, they didn't have time to do a voir dire or do a hearing on him beforehand. That's why they have it right now when the trial was supposed to have started 30 minutes ago. Jury might be having Lunchables. Could be. I don't know what a Lunchable is, but I've seen something that streamers make something that's also gross.
It's just crackers, cheese, and meat, pretty much.
Anything a good kid needs to grow.
Yeah.
Hey, Venus. Everything, everyone is saying it's so cold. I had ice on my car when I drove to the gym at 11 this morning. That's a little bit late. That's BS. They've had this case for 3 years. That's what the lady was arguing for, that they weren't given enough time to interview this expert. We see it in some cases that it'll pop up. But again, if he's just coming in to give a voluntary intoxication defense that he was somewhere between 0.05 and 0.12 in a BAC, yeah, it would be illegal for him to drive in Denmark. But again, it's such a, there's more than 100% difference on those two numbers. That's not evidence. It's the same problem I have with the Karen Reed thing. Fried bologna sandwich.
Dr. Lewis, you said that you got your doctor of psychology in 2000.
A jury will always be sequestered in that term. They will always be when they are in court. They are locked into a room and can't talk to anyone. So it's more when they're done here, they have to go to a hotel because they are from Nashville. So they will stay at a hotel during the trial. I don't know if they'll be able to go home on the weekend, but they will always, when you're in court, you will always be away from everyone else as a jury.
19, is that correct?
That is correct.
But you were not licensed as a psychologist until 2021, is that correct?
That is incorrect. I was licensed in August 2020.
Okay, August 2020. And then in Virginia, it was August of 2021, is that correct?
That is correct.
All right, so licensed as a psychologist, and your degrees in clinical psychology, which is different than forensic psychology, correct?
It is the generalist form, but forensic psychology is a specialty. One must be a clinical psychologist in order to be a forensic psychologist.
So I'm sorry. Did you get a degree in forensic psychology or clinical psychology?
No such degree exists. You cannot get a doctorate in forensic psychology and practice as a forensic psychologist. You must be a clinical psychologist first, and then you must specialize in forensic psychology.
I understand. Okay. And you stated that the Chicago School of Professional Psychology is in Washington, D.C., is that correct?
Yes, I was at the Washington, D.C. campus.
You went to school physically in Washington, D.C.?
No, I did not. So essentially what happened.
That's why I'm saying I don't know if they're sequestered, but they are driven in from Nashville. That could be that they are allowed to go home in the weekends, but I don't think so. That's why they are at a hotel, because they had to pick up a jury from another town because they didn't believe he could get a fair trial in Chattanooga because it's been a big case locally. So they had to go to Nashville, pick up a jury, and drive them up there. So the sequestration thing, I haven't heard him say they are sequestered. I've just said they stay at a hotel. So I don't know if they're going to stay over the weekend or be able to go home.
Was I earned my degree, or I matriculated at the Georgia School of Professional Psychology in Atlanta, Georgia. While I was on predoctoral internship at the Superior Court of the District of Columbia, unfortunately, the school abruptly closed while I was on predoctoral internship. And so what happened was the American Psychological Association, in addition to the Department of Education, moved those of us who were affected by the school's abrupt closure to the Chicago School of Professional Psychology in Washington, D.C. So essentially, it was somewhat of a pro forma or formality in terms of a teach-out agreement that was reached by the Department of Education and the American Psychological Association in 2019.
You went to online school?
No, sir. Excuse me. No, ma'am. You cannot go to online school and graduate and get a license in Georgia. You must go in person. I went in person for 4 years to get my didactic instruction, and then I matched to my first choice at the Superior Court of the District of Columbia.
But on your resume, it states from 2015 to 2019, you were a psychometrist in Atlanta, Georgia.
I was. I went to school in Atlanta, Georgia, ma'am.
But your resume says that you went to the Chicago School of Professional Psychology in Washington, D.C.
Okay, so let me explain again.
I'm sorry, I'm confused. Yeah, I'm very confused.
I know I'm going to help you if you allow me to, ma'am.
To me, let's be honest, I don't care if it's an online school or if he's whatever kind of school. If he's qualified, if he has his degree, it doesn't mean anything if they went to Harvard. That's why I hate these expert voir dire things, because they will sit there and say, "Oh, so you only went to Harvard? You didn't go to the Ohio State Penitentiary, State University." Same thing. Jamie hates them. It doesn't matter if he's qualified as a psychiatrist. He's qualified as a psychiatrist. And again, if he has 1 year or if he has 50 years, it's for the jury to say this is a credible expert or it's not. If he has the knowledge that's necessary to give an expert testimony, it doesn't matter if he went to. Didn't Trump have an online college once? I think you can. Is it Arizona or something that's famous that you can get a degree from?
Yeah, I remember that because they used to have like infomercials during like talk shows in the morning to like go to school online
Yeah,
in Arizona or something. Some Arizona thing.
I should get a degree in Christology.
Yeah.
So I matriculated at the Georgia School of Professional
It's Phoenix.
Psychology,
Thank you, Brandon.
which was located in Atlanta, Georgia.
Phoenix University.
While
I
I went
believe.
to school in person, because I come from humble beginnings, I also had to work. So I worked as a psychometrist alongside with getting my doctorate from the Georgia School of Professional Psychology. Part of the training in psychology is this. You must go to school for 4 years and receive didactic instruction and practical experiences. Then you must match at an APA or American Psychological Association accredited internship. I matched at my first choice, which was the Superior Court of the District of Columbia. While I was on pre-doctoral internship, which is a year-long working supervised experience, my school, the Georgia School of Professional Psychology, abruptly closed around March the 8th of 2019. The Department of Education and the American Psychological Association, understanding that we were about to graduate and the school closed, did what is called a teach-out agreement. The teach-out agreement was with the Chicago School of Professional Psychology, the Washington, D.C. campus. And that is where I graduated from.
Okay. Your resume states that you are an adjunct assistant professor at Emory University. So the year that you received your licensing, you also became an adjunct assistant professor at Emory.
Yes,
And your LinkedIn says that you've been an adjunct assistant professor from September 2021 into present. So which one is correct?
what is correct is what's on my CV. So what happened was I graduated from the postdoctoral fellowship program in 2020. As soon as I graduated, because of my work, they wanted me to stay on to teach others. And so 2020 would be the correct date.
So September 2021 on your LinkedIn is not accurate.
If it says September 2021 on my LinkedIn, it must not be accurate. Let's go with my CV, please. That is the most up-to-date and accurate.
Okay. And a lot of your work has been with inmates, correct?
That is correct.
And a majority of your work has been, has involved defendants' competency to stand trial, is that correct?
I wouldn't say it's the majority of my work, no. I've done a lot of work with competency to stand trial, and I also was integral in developing a jail-based competency restoration program, and I've also published on competency restoration. But I wouldn't say it's
Yes, a forensic psychologist is what he's supposed to be. People are saying he's shifty when you have to explain it that much. Again, if he has the piece of paper that means that he did the exam, again, I could say because he comes from a less fortunate background, work experience to me counts a lot towards knowing what you're doing. But it will be interesting that if he only testified on behalf of defendants, that's always what I look at, because like Dr. Gould from the JDAH case, he seemed like one of those expert for hires that will always find the result you need.
Yeah, and I mean, like the school meh, but his experience, what he's doing, like if he's doing the work and people are
Yeah,
hiring him, then I don't really care what school he went to.
yeah. But again, the jury are always the weigher of the expertise.
What is the majority of your work?
The majority of my work just includes the specialty of forensic psychology. So I do civil and criminal work, and it really just depends.
What is the majority of your work?
I wouldn't ascribe anything as being the majority other than the work of forensic psychology. So forensic psychology includes both civil and criminal work, and that is the majority of my work. It's not a particular type of evaluation or type of activity that I would say would be the majority.
Okay.
The specialty is the majority.
Okay, and you testified that you have testified approximately 10 times in both criminal and civil court?
In totality.
10 times, and how many of those times were in criminal court or in a criminal case?
I really don't recall. I would say the majority of them were criminal. I think only 2 of them involved civil, and that was parental fitness / custody type evaluation. So I would say it was definitely the majority of criminal. I probably prepared over 100 reports for the court, and so I would say the majority would likely be criminal.
Okay, so 8 criminal cases. Of those 8, how many involved a homicide?
1.
Okay, and what did your testimony involve in that case?
I don't know if I can get into the specifics of that, but what I will say is that I was retained by the defense on that case.
Why can't you get into the specifics?
Was
of
your
an open
testimony
court?
regarding the defendant's competency to stand trial?
Oh, no. My testimony was regarding mitigation for sentencing.
So you testified at a sentencing hearing?
Yes.
And you understand that there's a difference between testifying and being tendered as an expert witness and qualified by a court as an expert witness, correct?
In the state of Virginia, where I testified for this particular case, I was for here.
How many times have you been qualified by a court as an expert witness?
I would say approximately 10 times.
Where,
Each time that I testified, I had to be for here on both sides.
I'm not asking about what year, I'm asking about tendered and qualified as an expert witness in a case. Qualified as an expert witness.
If I'm understanding it correctly, approximately 10 times.
That's called Baker's technique of dating. The looser their morals are, the easier it's for me to get into. I should shut up.
You testified that you often do evaluations on mental state at the time of the offense.
Yeah. So it's called different things based on the state. So in Georgia, it would be called criminal responsibility. In Virginia, it would be called insanity evaluation. So I just generally said, but both of them are the same in that it is assessing or evaluating one's mental status at the time of the offense.
You believe that insanity is the same as mental culpability?
No, I don't think I said that, ma'am. What I was saying is that the statute is named differently based on the state. So some would call them mental status at the time of the offense. Georgia, for example, calls it criminal responsibility, and Virginia would call it insanity. But it's state dependent, and the state determines what the legal standing is for that.
Not really, but
Okay.
while I'm sitting down, it doesn't do anything. It's when I have to get up and walk around.
On your resume, there's a section entitled Adult-Clinical. And it states that in 2011 and 2012, you were, it doesn't say what your position was, it just says adult psychiatry / co-occurring disorders inpatient at Virginia Baptist Hospital.
That is correct.
But in 2011 and 2012, the only degree that you had was in mathematics.
That is correct.
Virginia Baptist Hospital was allowing you to work in a psychiatry
It's fine.
department with a mathematics degree?
Yes, ma'am. So in Virginia, there is a title called Qualified Mental Health Professional, or QMHP. And as long as you have a bachelor's degree and you take the continuing education, they will give you a certification called a Qualified Mental Health Professional. And so that is what I became, and that's how I was able to work at Virginia Baptist. I also interned at Virginia Baptist under the supervision of a clinical psychologist while I was earning my terminal master's degree in clinical mental health counseling from what is now called the University of Lynchburg.
University of what? Christchurch?
They say Pittsburgh, but I don't know.
But at least he has work experience. That's more than some witnesses.
Yeah, I mean,
Lynchburg. Oh, Lynchburg.
oh,
1 moment, Earl.
I mean, any doctor.
What is a psychometrist?
Sketchy anyway.
A psychometrist is essentially an individual who has at least a master's degree, who has been trained to conduct psychological assessments, or which involves administration, interpreting, and scoring. And that individual must be supervised by a psychologist.
And your resume states that you were a psychometrist from 2015 to 2019, is that correct?
Yes.
And this is while
And
you
in
were,
that role,
what?
in that role from 2018 to 2019, I took on I was a reviewing psychometrist, which is a little bit different from actually administering the scores or administering the measures. So from 2015 to 2018, I was in person actually administering the psychological test, it's scoring and interpreting and writing reports. From 2018 to 2019 as a psychometrist, they had me review other psychometrist reports for their accuracy and then send them to the psychologist.
Okay. And let's turn to your teaching experience. From 2016 to 2018.
It's not unaliving by suitcase. There was a slight contributing factor of being stabulated 60 times. It could be the suitcase, it could be the stabulation. We will have to wait to hear the experts talk about that.
Mm-hmm.
Yeah, I don't think I feel sorry for the guy now and says, "Oh, this lady is just condescending because he's not good enough for her." So yeah.
You have two separate.
I don't think that the jury's going to give a crap about this.
No. If she pulls this in front of the jury, they will just sit there and say, "Could she stop talking, please?" Yeah, he went to school, so what? This is qualifying him as an expert in forensic psychology.
But I think like what he has to say doesn't really weigh that heavy on me because it's not going to make me, I don't know, but they got to do what they got to do. Like what he's going to testify to.
How about die? I don't want to die. That's weird.
In two separate places in your teaching experience, it says that you were a teaching assistant with the Georgia School of Professional Psychology.
What are the difference between those two? Why is that listed twice on your resume?
Because I was a teaching assistant.
This is because the defense sprung him as a surprise witness against, or as an expert witness for the defense. They didn't get notified, so that's why we have to have this voir dire now, so they can rule him out or rule him in. My understanding of how expert testimony goes, what we have heard so far doesn't disqualify him from being an expert, because ruling out an expert's testimony shouldn't be the rule. It should be the exception. It's the same thing when we're talking about Dr. Russell, Dr. Green, and not Dr. Green, but Mr. Green, and all of these people. There should be a very, very, very strong reason not to allow them to testify as expert witnesses, which he has a degree. Yeah, maybe it's from a crappy school, but still, he has the necessary degree. Then it's up to the jury to say, do we find him trustworthy? And it's up to the prosecutor to use cross-examination to show that he might not have the skill level necessary to give the diagnosis that he claims there is. Experts have a very, very broad leeway of getting in, and most of it is just some experience in the field. You don't have to have a special Harvard degree, Penn State degree, or from the mighty The Ohio State University.
Oh, God.
Amy's alma mater.
No.
For multiple professors.
I know, Jess, but I made a joke of it because I don't want to talk about diversity inclusion, because that's political. I don't care about it. I don't give two fucks about it. That's why I made a joke about it.
At my graduate program.
And you were also,
Mama Smith, this is a case with Jason Chen, who is accused of stabulating his girlfriend 60 times, throwing her in a suitcase, and dumping her by Suck Creek in Tennessee. There will be some discussion because her parents broke into his apartment to find some of the evidence, which will probably be one of the things that defense will use to try and get evidence out of it, even though the judge have ruled it should be allowed in, but they will try and use it to sow distrust to the evidence in that way. They have now brought in an expert who apparently is going to talk about a blood alcohol level that's so low that me having my Friday beer with Brandon probably gets me above the level he was at.
you were also a psychometrist at that time.
Yes, ma'am.
You were also working in Buford, Georgia in that time.
That was as an intern, but yes, ma'am.
And you were also in College Park.
Yes, ma'am.
Well, it's because I have a lot of Fleek and read people, and it's easier to. I like to paint word pictures or sad elephants on my whiteboard, but it's easier to use that as an example because everyone has seen those hearings. Oh, Notre Dame.
Let's turn towards this case. What were you asked to do in the case of State versus Jason Chen?
I was asked to assess or evaluate the issue of premeditation.
When were you asked to do that?
December the 10th is when I was asked to do that, of 2024.
When was your first communication with defense counsel in this case?
It was late evening, December 7th of 2024.
And you said that you were asked about premeditation. What does that mean?
Premeditation as defined by the state of
I'm
Tennessee.
dyslexic. All the cool people are dyslexic.
as it relates to Jason Chen?
Yes.
What is the
It's even later because the prosecution wasn't notified about him till Saturday. That's why we're having the pre-trial hearing instead of having opening statements, which we were supposed to have started an hour ago. The prosecution wasn't notified about this expert till Saturday around, I think, 11 o'clock. At the same time, they're supposed to start a case Monday. Haven't been notified that they're going to call this. Haven't been notified about his testimony, which they should be allowed to, because they would be allowed to bring in a rebuttal expert. So they would. It's just. It seems shady from the defense. I have to say that.
offense date in this case?
Well, you can do the same questions all the time.
I don't recall the exact offense date. I do recall that it was in 2022.
Okay.
I believe it was November of 2022.
And were you asked to evaluate the defendant for mental condition?
Yes, I suppose that was a part of it, yeah.
What were the other parts of it?
Well, the only thing that I was asked was about the issue of intoxication, but of course, if I'm conducting a psychological evaluation, there is a possibility that a mental condition could emerge or be revealed. But my understanding, my understanding was that that individual had never had any mental conditions. But part of a psychological evaluation, such could be revealed.
Did you decide that Mr. Chen has a mental condition?
I did not give Mr. Chen a homework notice. However, Mr. Chen does have some, what I would call some mental health or psychiatric challenges, to include depression and anxiety.
Dr. Lewis, I'm sorry to interrupt. The technical transmission of what you said a moment ago didn't completely come through. I think I understand what you said, so make sure you say you did not give him a formal diagnosis.
That is correct. So I did not give Mr. Chen a formal diagnosis. However, I do know that he has some psychiatric or mental health challenges.
How do you know that?
Depression and anxiety, based on psychological testing, based on my interview with him and my observations of him.
When you say psychological testing, are you referring to the tests that are mentioned at the end of your memorandum?
Yes, ma'am.
And are you aware of how long Mr. Chen's been in the Hamilton County Jail?
Approximately, since his arrest, I would say approximately 2.5 years.
And are you able to opine as to when he developed his depression and anxiety?
My opinion is that he developed it during childhood.
So I'm assuming that you had reviewed his medical records from childhood forward.
I reviewed what was in the discovery, and in the discovery, I did not see any medical records.
I'm assuming that you interviewed his parents to learn more about his childhood.
I reviewed the statements that were in the discovery from his parents, particularly his mother. But other than that, no, I did not interview his parents.
The statement from his mother that included that he did not have a mental condition?
Yes. I saw that in the discovery, multiple times individuals indicated that he did not have a mental condition. I disagree.
Because Jason told you that he did.
No, he actually did not. He said he doesn't have any problems either.
So what did you rely on? You had no medical records. You did not interview his mother and father when it comes to childhood issues. The defendant denies having any kind of mental condition. What did you rely on?
I relied on my years of experience since 2010 of working in the mental health field across jurisdictions. I also relied upon my review of the discovery, all the documentation that was in there. I relied upon my interview with Mr. Chen, which involved many questions, to include questions that are diagnostic, questions that are violence risk, questions that are about his sexual history. I also relied upon objective, tested, psychological testing that is peer reviewed, and all the other things that were in discovery. And that is what I relied upon, which is best practices in terms of the field of forensic psychology. It was a multi-method approach.
You've only spent 3.5 hours with Mr. Chen.
Approximately 3.75 hours.
Oh,
Yes.
I apologize. You've only spent 3.75 hours with Mr. Chen in Mr. Chen's entire life.
That is correct.
And that was last week.
if I was her, I would actually have him in and have him testify about that, and then hit him with the. But you didn't see him for more than 3 hours, because anyone who have had any type of interaction with a therapist in the jury would sit there and think, you met him for 3 hours and you could diagnose him without talking to anyone else, and he denied having mental health problems. To me, that would lessen his expertise or his statements in the eyes of a jury. To me, that seems more like, oh, this is a hired gun that they got in here to try and paint him as a poor victim.
Yeah, they could use that to their advantage.
James,
Yeah, but I think sometimes prosecutors don't think really tactically. They oh, we're gonna eliminate him. No, you can turn it around and use their bad testimony against them to show that the defense is grasping at straws.
Yeah.
wait a second.
And you administered 3 tests during that 3.75 hours?
Yes, that took him about 50 minutes or so to do, the 3 tests.
50 minutes. He did 3 tests in 50 minutes?
Yes, one of them, you have to finish within 16 minutes for it, because it cuts off. So one of them was time.
So, and then the rest of the 3 hours, you just simply asked him questions about his mental condition that he doesn't have?
No, I asked him questions basically about his life from birth to present.
Yeah, but she's trying to get him tossed out as a witness right now. That's that I would say, well, Judge, after hearing that he's clearly competent, I'll have him on, and then I'll have him stutter through this in front of the jury.
So those questions are across the board. Some of which are the questions you don't really know, or the individual or the examinee really doesn't know why I'm asking the questions that I'm asking. They appear they're not face valid. So the questioning is not just about a mental condition.
You base your opinion that it's highly unlikely that Mr. Chen could form premeditation in 2022 based on 3.75 hours with Mr. Chen. 50 minutes of those were consisted of him taking 3 tests to help you decide this issue.
And also over 14 years of experience of working with justice-involved persons.
And one of those cases in 14 years involved a homicide.
No, many of them did. Only one of them I testified for, but I've done many murder cases that I've written for. Usually the court stipulates to my reports. So I don't testify a lot.
Well, but your reports don't have to do with premeditation at the time of the offense.
But they have to do with murder, which is what you asked, I thought.
Okay. None of your reports have had to do with premeditation at the time of an offense.
No.
And in your memorandum to the court, did you mention depression or anxiety?
I don't believe that I did say that. I don't believe I said that explicitly. However, if you look at the end where the tables of the testing, even a layperson can see that some of the scales are elevated regarding depression and anxiety. But no, I don't think I explicitly indicated that in the memorandum.
Have you ever been in jail, Dr. Lewis?
As a professional, yes, I've been in many jails and prisons.
Of the people.
No, we'll be don't go back. It's just they're fighting about letting this guy in as an expert witness because the defense dropped him on the state very late. It's just a motion hearing. You don't miss anything if you stick around. He's not the best witness, I'll say.
That you've worked with, how many of them experience depression and anxiety?
Probably most of them.
You stated in your memorandum that you relied on a handful of articles or websites, in one case, a book, to form your conclusion in the case of Jason Chen. Is that correct?
Relied on is probably not the right language. I would say that those items, in addition to all the other methods, is how I form my opinion. So essentially, I provided those for individuals who are not versed in mental health or forensic psychology, etc. But yes, those were a part of forming my opinion because it gives foundation of knowledge for those who are not privy or not scholar in this area.
Sure. Your report says, and a review of pertinent research, and then it cites to footnotes 5 through 15, is that correct?
That's right, ma'am.
And number 5, the title is Proactive and Reactive Aggression, a developmental perspective. Are you going to opine about Mr. Chen's aggressive behavior?
I intend to educate the board about, some people call it in literature proactive and reactive aggression, and then in some literature it's called affective and predatory aggression or violence. And so what I want to do is educate the board about the difference between affective or reactive aggression versus predatory or proactive aggression.
And what does that have to do with Mr. Chen's mental state on November 23rd, 2022?
Well, what that has to do with it is that in terms of premeditation, typically one shows that they have predatory or proactive violence or aggression. And there are certain items that must be there, or factors or traits that must be there for such. When in issues that are raised about premeditation where someone's arguing that an individual doesn't have premeditation, then one would look at affective or reactive aggression, because those have certain elements or traits. And so what I would like to do, what I intend to do, is to educate the court on the differences of the two.
You understand in this case you would not be testifying to the court, right?
We're not testifying to the court. I'm saying educating the court about the difference, because the differences of those two items goes into my opinion about the issue of premeditation.
How do those issues relate to diminished capacity?
They don't relate to diminished capacity.
But that's what you're finding is from Mr. Chen.
I didn't say anything about diminished capacity. I didn't use those terms. My understanding is that that is not a term that's in Tennessee, that it is recognized in Tennessee, but I'm not using those terms. What I'm saying about Mr. Chen has to do with affective or reactive aggression, as well as the impact of substance use. However, I'm not explicitly using those terms or that term.
So what is your finding as to Jason Chen's mental condition on November 23rd, 2022?
My finding is that Jason Chen likely displayed affective aggression while also under the influence of substances.
And what evidence or information do you have that Mr. Chen was under any type of influence of substances on November 23rd, 2022?
In terms of evidence, the only thing that I have is that his report that he was using substances, and also.
Come again now?
22.
In terms of evidence, the only thing that I have is that his report.
So he's going to testify that he was under the influence because he self-reported he was using some kind of substances at the time.
That's not gonna fly.
What?
Yeah.
So you can't prove he was drunk or high or whatever, but you're going to state it because he told you? Jamie told me if I kept the channel going for 2 years, she would allow me to have 0.0001% of the super chats, which I had to pay taxes off. Still haven't happened. And I said, but you promised. And she said, prove it. I said, but you told me. That's not proof.
I'm the worst.
I've never heard anyone. Yeah, Trooper Paul said the crime scene told him stuff. It's the same thing. At least they had a bungled up BAC report that the guy who testified to it never saw the blood draw or the test of the blood. This guy doesn't even need the blood. He's probably drunk. What, if any?
Like, you can make it look so stupid. So just stop fighting it and be like, okay, let this guy in because he's.
Yeah, it's going to be fun.
Yeah.
He was using substances, and also by my question of him, many of which were not face valid at all, it appears that he has been using substance for many years.
You'd agree that using substances for many years doesn't mean that you were intoxicated on November 23rd, 2022, right?
I do agree with that. However, in my work with substance users and individuals that are just as involved, people just don't stop using substances.
So you are going to testify that Mr. Chen was under the influence of a substance on November 23rd, 2022 because Mr. Chen said he was?
I'm not going to testify directly in that way. What I'm testifying to is that he reported that he was under the use of substances. And the psychological testing suggests that he does have issues with drugs.
So you
So
can't.
I'm not directly reporting that. I'm reporting that that's
What are you saying?
And based on his
That he
psychological
was
testing,
pressed?
it suggests that he does have issues or challenges with drug use.
Well, you said you'd gone through discovery in this case, correct?
Yeah,
When did you receive discovery in this case?
it had to have been the week of December 17th, because it wasn't until December 17th that the Tennessee board allowed me to have temporary authorization to conduct the evaluation.
So, homicide cases involve an extreme amount of evidence, correct?
Yes, they do.
And between December 17th and January 7th, would you say that you went through all of the discovery that was delivered to you by the defense attorney?
Between then and January 7th, I would say no. I went through most of it. And since that time, I have gone through all of it.
What did they deliver to you?
There were pleadings, there were mitigation documents, there were police reports, there was a medical examiner's report, there were pictures of the deceased, there were pictures of Mr. Chen and his family. There was a transcript of his bond hearing back in 2022. There was a lot.
And what in that discovery indicated that Mr. Chen was under the influence of a substance on November 23rd, 2022?
I don't believe anything explicitly indicated that.
And what was that substance?
He reported that he and the deceased drank an entire bottle of wine, and after they drank an entire bottle of wine, they smoked joints or marijuana, and then they also had wax, which is concentrated THC.
I think that he testified that the defense contacted him 7 days before, maybe 10 days before. So 7 or 10 days. Yeah, I think either wax or glass. I don't do the devil's letters, so I don't know all the slangy things you use for it. But yeah, let's. This is stupid. Yeah, a bottle of wine. How many? There's 6 glasses of 6 units in a glass in a bottle of wine. So that's 3 units each, and then you had some devil's letters. That's normally how people turn stabby. That's why, Roger, don't touch that devil's letters.
But you'd agree based on the autopsy report that there's evidence to the contrary of that, correct?
I think the question was specifically to reports, or I guess it's not called report, the medical center's finding. So I think it's looking into.
You'd agree that based on the autopsy report, there's evidence to the contrary. Is that correct, Dr. Lewis?
I would agree, but I think that the question you're asking is a bit misleading, given that the body was found and given how the testing was done. Apparently, based on what I saw, it looked like the testing was stopped for some reason. And then also because there had been some time that had passed, and the way that any type of drug enters your body, there's a time where it has a half-life. So it starts to diminish or denature. So I don't think that is a clear question. I would say that yes, the medical examiner said that there was nothing found in terms of substance use, but I don't.
Are you qualified as a medical examiner? I'm pretty sure you're not. And now you're testifying that there was, well, you're not testifying, but you're saying that they did a shoddy job on the investigation, so you claim that there was no evidence because they did it wrong. She must have. Oh, I don't like. You are a gun for hire. I don't like that.
I think that question's a bit misleading.
And Dr. Lewis, you don't have a degree in forensic pathology, do you?
I don't, but I know what I've read.
And you don't have a degree in pharmacology, do you?
I don't. However, when you are trained to be a clinical, you do have to take psychopharmacology. So I had to learn about pharmacokinetic in terms of medication.
And you can't, as a psychologist, prescribe medication, can you?
I cannot, the psychologists do. They do.
Okay, well, I'm not concerned about other psychologists. You can't prescribe medication, can you, sir?
That's correct.
And your basis of knowledge pertaining to marijuana, based on your memorandum, is one of them is from the DEA website?
The DEA website is good information for laypersons, but I have treated and worked with people who have substance use disorders. So again, what was on the memorandum was for people like you and others who are not trained in working with substance use disorders or psychopathology, and that was for a reference that would be easy for you all to understand. However, I am not solely basing my opinion on the 15 citations that I gave.
Well, it's a proper hearing. It's not like he's testifying in front of the jury. So, but still, yeah.
In my opinion, on years of working with individuals in different.
I have one better. They sent me a letter that we were going to get we could write if we didn't want a cell phone mast 2 months after it had been put up. Danish cities works every time.
Jurisdictions who have substance use disorders and also have mental disorders.
But in your memorandum, you'd agree that you referenced these specific articles as what you reviewed to help you form your conclusion in this case.
I said that those articles were useful.
Gina, don't go back. They're just trying to figure out if this expert is an expert. He's not. He's so experty he can testify about things that's no proof of.
In forming an opinion. However, they're not the only things that I use. Part of being an expert is that it's the years of working with individuals who have similar or the same types of challenges. So I would not hinge my opinion on just 15 citations. It's also to allow the reader to understand what it is that I'm talking about. So I don't want to be misleading and have you think that only 15 citations, one of which was a DEA website, is how I came up with my opinion. It's actually my years of training and in practice with individuals.
And which of these articles have to do with a defendant's mental state at the time of an offense?
None of them.
I think he's teaching.
Which you'd agree is what you would be testifying on, correct?
Yeah.
Okay, and your resume has a lengthy list of publications that you, along with others, have published over the years. The last publication being in 2022.
Yes, ma'am. And I made that publication. That publication was republished by the NIH, or the National Institutes of Health, in 2023.
That's great. Okay, yeah, that one was the need, the controversy, the impact of COVID-19, right?
Yes, ma'am.
Okay, and then can you point to which of these publications has to do with a defendant's mental state at the time of an offense?
None of them.
Oral presentations, you cite 21 oral presentations, several of which you would agree included yourself and other presenters, correct?
Yes, ma'am.
And which of these presentations that you gave relate to the defendant's mental state at the time of an offense?
None of them.
How many times have you testified to a defendant's mental state at the time of an offense?
Once, on the side of the prosecution.
And in that case, did you interview the defendant?
Yes.
For how long?
About an hour.
How far was that interview from the time of the offense? How long after?
I would say approximately maybe like 10 or 11 months after.
And what was your opinion in that case?
My opinion was that he was sane, or he knew what he was doing. So I was on the side of the prosecution.
So that had to do with sanity, is that correct?
Well, in the state of Georgia, it's called criminal responsibility. So I found he was criminally responsible.
We just said sane. So is it sanity or criminal responsibility?
It's criminal responsibility. The case was in Georgia.
She's a little
What type of
cloudy.
homicide was that?
It was not a homicide. It was an aggravated assault.
So you've never testified or opined regarding a defendant's ability to form premeditation in a homicide case.
I've written reports that I have opined that they were criminally responsible of a homicide. But I've never testified. But I have written reports in murder cases where I found them criminally responsible for the murder.
A report for what? I don't understand. For
Okay, so-
sentencing?
No. So there's two types of reports that are common in courts. One type is called competency to stand trial, and the other type is called, based on the state, it would be either criminal responsibility or insanity evaluation. Those reports, or excuse me, those types of evaluations are ordered more than any other type of evaluation. And so often I would perform a competency to stand trial evaluation as well as a criminal responsibility evaluation. So these things happen pre-adjudication. They're not sentencing or mitigation.
Where do those reports go?
Okay, so the competency to stand trial evaluations typically go to the court. Now, the criminal responsibility evaluations go to the defense typically, because that's usually more of an ex parte issue. And when it comes to sanity or criminal responsibility, essentially people see it as a legal strategy at times, because it depends on how the attorney wants to work through the case. So those types of reports only go to the defense attorney typically, because the individual is admitting that they committed the crime, and I'm evaluating their thoughts or actual behaviors before the crime, during the crime, and after the crime. And for that reason, typically those reports do not go to anyone but the defense attorney, who decides how they want to work the case.
They're never intended to be introduced in a trial or in a hearing for the defendant's guilt, right?
I can't say that because I'm not an attorney. I'm not sure how they use it afterwards.
Well, where is that report in this case?
Pardon me?
Where is that report in this case?
Those type of reports are ordered by the actual judge. So if it's not ordered by the judge, then there is no report. I was retained by the defense, and when the defense or the prosecution, whoever retains me, they ask a question, and I'm the one who is evaluating the question that they're posing. But those type of reports are typically ordered by a judge.
What was the question in this case?
The question in this case was to again evaluate or assess the issue of premeditation.
That's not a question. What was the question in this case?
That was the question.
To evaluate premeditation is not a question.
Sure. Okay. Determine whether or not Mr. Chen had premeditation in this particular case. I'm not sure how you want me to word it.
Okay.
That's what I was asked to evaluate.
Okay. Let's go to the test that you administered in the 15-minute time period you met with Mr. Chen in the Davidson County Jail. TOGRA is intended to measure reasoning and critical thinking. Is that correct?
Yes, ma'am.
And Mr. Chen, with a 94, was within the standard deviation, correct?
Yes, ma'am.
And you'd agree that school records probably also could indicate someone's level of reasoning and critical thinking. Is that right?
They could. However, there could be a little bit of politics when it comes to school records, like individual education programs or 504 plans. Sometimes individuals can be labeled or mislabeled depending on their behaviors in school. And so I would not use school records as the only standard in making an opinion.
So did you
Particularly
review?
when I work-
Did you review Mr. Chen's college transcripts?
No, I did not.
Are you aware that he had a scholarship to the University of Tennessee at Chattanooga?
Yes, and I actually asked how did that happen. given some of the information that I learned about his, some of his own reports about his behavior in school, I was curious about that he did earn a scholarship. But different scholarships have different requirements. So I know that scholarship that I'm aware of, he likely wouldn't have been necessarily a person that would have got some scholarship I know about. However, yes, he did report to the scholarship.
What does reasoning and critical thinking have to do with affective aggression?
Well, I don't think the two are directly related. However, one must have a certain level of reasoning and critical thinking ability to be responsible, knowing, or intelligent. One must have those attributes. So part of the reason why I did that testing was to get an idea of how he's functioning cognitively. And he's functioning in the average range in terms of when compared to other adults. So that's why I gave that test.
Okay, and did this test measure how he was functioning cognitively on November 23rd, 2022?
No, ma'am. However, I will say that intelligence cognitive functioning tends to be stable.
Marissa says, gotta run to a call. I bet $5 this guy's going to come in, even though he shouldn't. He's qualified. Again, the level you need to reach to be an expert is so low that I won't take that bet. I'll only take your monies. Yeah, he did write his report. They just dumped it on them very late. But it's a good report.
Unless something happens like a traumatic brain injury or some type of other injury, typically intelligence or functioning is stable, particularly at a certain age group in the lifespan.
I understand. So if he was functioning cognitively in January of 2025, he most likely was functioning cognitively in November of 2022, based on what you just said.
Yes, in the absence of substances, absolutely.
And personality assessment inventory. Which one of these tests take 16 minutes?
The children.
And then how long do the other two tests take?
It depends. Some people have gotten it done in 20 or 25 minutes. And then some people have taken hours to do it. It just depends.
How long?
It's basically questions that says it's mostly true, slightly true, false, never. So it's things like that. So the items are short. Like some of the items might say something as short as I like airplanes. It's not much. You don't have to do much thinking. It either is or is. So it depends though. Often people who take a long time are people who are misleading, and they typically invalidate the test because they're thinking too much.
So in 50 minutes, you're comfortable with a criminal defendant charged with first-degree premeditated murder taking a test of general reasoning ability called TOGRA, a traumatic symptom inventory, and a personality assessment inventory?
I was with him for longer than 50 minutes.
No, that was my
I said it
question.
was okay.
Are you comfortable?
Can you rephrase?
Are you comfortable with a defendant taking 3 psychological tests within a 50-minute period that you then rely on?
That was part of a multi-method approach. Yes, I would not rely just on that. No. So I think you already mentioned all the things that I did rely on, but just the testing, no. So it's best practice that you do a multi-method approach. So I would never hinge an opinion just on testing. It's everything. It's everything that I would use.
For the trauma symptom inventory, TSI-2, it says that the clinical scales reflect 4 broad categories of distress: self-disturbance, post-traumatic stress, externalization, and somatization.
Somatization, yes.
Can you explain which of those has to do with the defendant's mental state at the time of an offense?
So that particular testing doesn't mark directly to.
Why is Jamie always hating on others? She's like the cat lady from The Simpsons, but with dogs instead. She does have cats. She can
What?
chuck one of them at you.
I haven't said a peep in like a million years. Get out of here.
Maybe it's because one of the questions are that Jamie's mean.
Oh, I am a hater. Yeah, well, she is a whiny, but hey, I mean, I know she's doing her job.
Yeah. This doctor said there's no history of aggression from the defendant, but that's incorrect. Previous roommates have stated the defendant has been aggressive so much that they locked the door at night. Interesting. Don't leave, Lefty. Jamie will yell at you a little bit again.
Yeah, why are you leaving?
To a mental status at the time of the event. What it does is it gives me a profile of how this person is social emotional function. So does this person lash out at others? Do they have anxiety? Do they have depression? Have they experienced trauma in their lives? Are they likely to become easily angry or agitated? So what that does is it's one component of giving me an idea of this personality profile, but it does not. There is not a test that loads directly onto a legal issue. That's not how testing is designed.
Okay, and so the same thing for the personality assessment inventory. That test has nothing to do with the defendant's mental state at the time of the criminal offense, does it?
Not directly, no.
Do any of these have to do with substance disorders?
Yes.
And do they have to do with a defendant's use of a substance 2 years prior to the test being given?
So typically, what it does is ask innocuous questions that essentially we create a personality profile. While individuals are different, there are certain challenges that people have that are very similar. So what we've developed through the testing is we are developing a personality profile, panoramic of how someone is functioning. So no, it does not necessarily it's not as specific as you're asking. However, when I talk about likelihood, there's a certain personality profile that is developed by use of the testing and the other sources.
Can we get over this?
Describe some of the, since you reviewed the discovery in this case, Dr. Lewis, can you describe some of the things that the defendant did after he murdered Jasmine Pace?
He visited a convenience store.
Objection. I don't know the relevancy regarding his qualifications. I don't know how that question answers. This is where here.
It seems like it could apply to both, I guess. In the sense that it's maybe relevant to his opinion, maybe relevant to his qualifications. He gives a great weight to it, not much weight to it. So at this point, feel free to review your objections to once anytime. It gives grace to the
Okay, continue, Dr. Lewis.
He went to go purchase cleaning products.
And what else?
He also moved the victim's vehicle. He used the cleaning products to clean up his apartment.
And what else?
He left the apartment, I believe, to stay with his parents.
And what else?
I'm not sure what else you're asking me.
How much weight do you give to what a defendant does after a murder when it comes to premeditation?
When it comes to premeditation, I give it great weight. I find those details, quite frankly, to be aggravating.
What do you mean?
What I mean is that essentially, if those actions are the actions he took, then it appears that he attempted to hide or cover up whatever act that he committed. So I take great weight to that. I found that aggravating. However, I do not find that it is suggestive of premeditation.
No, just stay here. It's the same over and over again. He relied on his expertise, and he read something, and he trusted the guy he was interviewing.
Quite frankly, I find it to be the opposite in terms of the individuals I work with inside the carceral environment. If they engage in forethought or planning, they typically would not do the action in the way that it was reported that Mr. Chen did. It doesn't fit the profile of someone who engaged in forethought and planning.
But in Tennessee, premeditation doesn't require planning, right, Dr. Lewis?
Based on what I read in terms of premeditation, it means that you have to have some type of forethought before the action is done.
You'd agree that somebody who is under the influence of a substance would have, how would you say it? Well, a difficulty completing tasks that a sober person may be able to complete, correct?
They probably wouldn't be able to do it in the exact same way. But someone who's been doing substances for quite some time, they may be able to function a little bit better than someone who perhaps is just starting stuff.
So if Mr. Chen was a regular marijuana user, he probably could have functioned a lot better if he was under the the influence of that substance?
He may have been able to. However, he also said that he used wax, which wax is a much greater concentration of marijuana or THC.
Do you take into consideration when forming your opinion that criminal defendants will most likely say whatever they need to say instead of going to prison for the rest of their life?
Absolutely.
How is that factored into your decision here?
I didn't give great weight to it. It's part of the decision, but I didn't give great weight to the use of the substance. I gave more weight to the personality profile type that he fits into, more so than the use of a substance. He did report that he used a substance. The testing shows that he might be a substance abuser. However, that is not something that I gave great weight to.
You did not give great weight to the use of a substance.
Great weight, no. It is a part of it. But I did not give great weight to it because, as you mentioned, he reported that he used a substance. But that's not something where I'm hinging my decision solely on substance use.
What did you give great weight to?
What I gave great weight to was the personality profile type that he fit. For example, my understanding is that the one theory is that he planned this murder because the victim was bound. So if you understand or if you work with individuals who have a psychopathic or so-called psychopathic personality.
I don't know. It's concentrated THC. I don't do weed, so I don't know. Yeah, he's saying wax. I know nothing about. I'm a goody two shoes. I'm a Boy Scout, and I do Bible studies on Sundays with Jamie. Wax is a concentrated THC product. Dabs are wax.
Yeah, Baker and I are little angels.
We are too pure for this world, Jamie. Yeah, and he doesn't know if he was using anything. He claims he was using. That's the thing. It's extremely powerful. Oh. I don't know. Anything other than rocks, I learned from Roger. Stay away from it.
Or who are a sociopath, you will learn that the details, as is mentioned in the theory that's been presented, is not it is not consistent with it's not consistent with the evidence. Someone who would conduct an act of that sort, they do it gradually. You don't just start out a murder in that type or murdering or harming others in that type of way. That is a gradual type of violence or aggression. So what I was looking at his personality profile type, and then I'm also looking at the different theories that were presented. And so what I'm saying is that we would expect to see other things within the personality profile type. There should be other violence or aggression. There should be other charges of violence and aggression. There should be a known history of maybe intimate partner violence. There's a lot of things that should be within the personality profile type and within the evidence, given the theory that's been presented, that's not there.
How many of
No, they are just trying to qualify this expert that the defense dropped on the state Saturday. So far, he will not be a good defense witness. He's relying on self-reporting, the least credible way of putting in evidence.
Mr. Chen's former girlfriends did you speak with?
None.
How many of Mr. Chen's friends did you speak with?
None.
How many of Mr. Chen's family members did you interview?
None. I reviewed what was written in the discovery.
So you're basing your knowledge on Mr. Chen's prior violent history on what Mr. Chen told you.
And I'm also looking at the legal record because you produced some charges for Mr. Chen in terms of violence and aggression. Because typically that's what those individuals like that's what they have at a much younger age. And now they start at 10, 11, or 12 years old.
Letting the jurors go downstairs and stress the legs. I don't want them to walk by and hear things.
Oh, they're just taking the juries out.
Welcome to Channel 9's Little Camp. Next.
Now they forgot to put the Audio on. Turn the audio back on. Are you effing kidding me? Is the audio on Lawn and Crim? What the hell? Yes, the audio is on Lawn and Crim. So, but the audio is bad on Lawn and Crim, but at least there is audio.
So, yes, I look at a personality profile, but there's also a specific type of question that you ask the individual.
In 3 hours.
Yes,
Okay.
and you review the evidence that's been collected, which is the discovery. So I look into things in the discovery as well. So testing, interviewing, and also the discovery is very, very typical in terms of best practices in forensic psychology.
You testified that you did not issue any formal diagnosis for Mr. Chen, is that correct?
That is correct.
But you just mentioned psychopathy and sociopathy.
Right, those are not necessarily diagnoses. Those could be personality profile types. So that's what I'm looking for. That's what I'm looking at in terms of your characterological function. So those are not diagnoses. So a diagnosis for something like that would be antisocial personality disorder. But psychopathy and sociopathy aren't a diagnosis. They are labels, or they are labels that tell us something about how the person's personality profile is, but not necessarily a full diagnosis. For example, you won't find that in the DSM-5.
Oh, the DSM-5. What is the DSM-5?
Oop, oop.
It is the book that we use that basically lists every mental disorder and their characterization of each one. So, for example, you will see something like major depressive disorder will be in the book. And there it says that this person has this, and that. And you use that manual in order to give someone a formal diagnosis.
Why did you not cite to the DSM-5 in your memorandum?
I don't believe it was necessary.
Is
I'm not sure how
Mr.
that would be necessary.
Based on your opinion, is Mr. Chen a psychopath?
No, he is not.
Based on your opinion, is Mr. Chen a sociopath?
No, he is not.
What personality profile does Mr. Chen have that caused you to come to the conclusion that it is highly unlikely that on November 23rd, 2022, he was unable to form the requisite mental state of this offense?
Just like any type of other mental status type of evaluation, I reviewed what his psychological or emotional functioning is, and what I found was there was a potential history of childhood trauma, there was depression, anxiety.
Dr. Lewis,
And you mentioned before.
I'm sorry to cut you off, Dr. Lewis. Hang on just a second, okay? Jurors are walking by, they don't hear anything.
So I was saying that he potentially has a history of childhood trauma. He experiences symptoms of depression and anxiety. He's younger than 25 years old. There's no known legal history that I found. That's why I asked you if you found any charges in terms of violence or intimidation. There's a history of misbehavior within the school setting. So those are all the things that that I put together in terms of over the course of evaluation. So there isn't a particular name, so to speak, of
Most Americans would probably find it very lax.
a profile. It's
Maybe he
a
turned on
profile
his
of who the
microphone.
person or individual is. And you compare it to, as you mentioned, something like a sociopath or a psychopath, you would expect different information to be in the actual profile.
Stupid face.
What does potential childhood trauma mean?
Well, the psychological testing revealed that there was likely a history of trauma. And then when he was inserted in during his childhood, a professional like me, and perhaps others, would likely characterize some of those incidents as abuse. However, Mr. Chen did not characterize it as such.
Mr. Chen said he wasn't abused,
Correct.
but you think he was.
However, he described the incident that he described, most professionals, and likely others would describe it as a form of abuse.
Well, did he describe them, or was that questions in his testing that you gave him?
During the interviewing, he told me about his childhood during the interview, so he described
Were there questions on the test also related to childhood trauma?
specifically childhood trauma. No, the testing was asking about basically what the testing does. It's not face value, so it asks questions that may appear to be innocuous to answering or to the examination. However, based on how he responded in the testing into the interpretation suggests that likely he has experienced trauma in the past because he matches how other people who we know for a fact have experienced trauma is how he responded. So what we do is we do comparison groups. So we're comparing how he responds to items to how others who we know are known to have certain disorders or certain life experiences.
What was that childhood trauma that he denied having that you found that he had based on what he was saying?
The childhood trauma, you know, categorized as trauma.
This is where it goes too far.
Okay.
I also think that we can get into it later when you get into it. Witness is allowed to testify further and he's recognized an expert. And if Josh wants to lay the foundation, you can ask him specifics later. Just think this one.
You'd agree, Dr. Lewis, that a majority of people with childhood trauma don't murder other people, right?
Absolutely, and I would never suggest that would be an excuse for any type of law breaking.
No. They have been in contact with him since December 7th or 10th last year, and then dumped him. Still, normally you wouldn't dump anything later than 5 days. I think is kind of the rule, but it's not a rule. You can always bend the rules, but no, he hasn't been contacted till 2024.
Would your opinion change if you would have spoken with former friends of Mr. Chen that would tell you that they were scared of him?
That would be speculation. I don't know if it will change or not. It would depend on the veracity of the information or the details of the events that his friends would say. So if there's information that's there, I'm more than willing to listen and to hear it. And yes, my opinion could potentially change. However, I have no way of knowing that until it happens.
Well, some experts would have interviewed people.
Absolutely, they absolutely would have. Yes, I think that is very much a common, I would say a common practice for some. However, it is not necessary or mandatory in terms of best practices, particularly not for mental status at the time of the offense or mental state type of evaluation. So I do certainly agree with you that does happen, but it's not necessary.
Why did you not come to Chattanooga to see Mr. Chen?
Because by the time I was available, he had been moved to Nashville. I didn't get clearance to even do anything until December 17th.
Okay.
And I was away
And then,
the 16th to the 20th. And then I was
I said this is okay. We're gonna move.
23rd or 24th until January the 3rd.
Hey, come on.
I was able to see him
Wrap this up.
January 2nd. By that time, he was moved to Nashville, which is where I went to see him.
Well, what about January 4th, 5th, and 6th?
Man, there's no way I could have done that because I took a 24-hour flight from South Africa. So I need to rest.
Couldn't have planned that if you get paid for it.
twice at this point. We're still trying to decide whether or not we qualify as an expert. State objective.
Chip, chip, chop,
Yes,
people.
Yeah, chip, chop, chip.
Your Honor.
Go.
Dr. Lewis has he was licensed as a psychologist in 2021, so he has several years of experience as a forensic psychologist. Okay, I apologize, in 2021 in Virginia, 2020 in the state of Georgia. Of course, he's not licensed as a psychologist in the state of Tennessee. He, in fact, probably has expertise in some type of psychology. But having an expertise in some kind of psychology does not mean that you have an expertise in a defendant's mental state at the time of a criminal offense. A podiatrist does not have an expertise in forensic pathology, even though they're both medical doctors. So no disrespect to Dr. Lewis, but as you go through, as we did, Dr. Lewis's resume, there is hardly anything in the resume or in his memorandum that has to do with reliability or trustworthiness of his findings as it has to do with the defendant's mental state at the time of the criminal offense. There is hardly anything. There is a lot regarding the defendant's competency to stand trial. That is not what we are here on. This expert cannot testify in toxicology. He is not, and I don't think this will be contested, he is not an expert in toxicology, which is apparently a primary issue of what he would opine on is the defendant's substance use on November 23rd, 2022 that he has no extra information on except for what Mr. Chen's told him. So he has no basis of knowledge. He is not an expert in the field of toxicology. He is not an expert in pharmacology. Sorry, Judge. Pharmacology. He is not a medical doctor. He has not presented enough facts and evidence of which he based his opinion on the defendant's mental state at the time of the offense. And in fact, Your Honor, the state is more confused after hearing his testimony because the defense alleged that the argument was diminished capacity, to which the expert adamantly denied that he was arguing diminished capacity. We now have a personality profile, childhood trauma. There's been nothing on the record that would establish that this expert should be qualified as a forensic psychologist as it relates to a defendant's mental state at the time of the offense. Moreover, he has not had enough time to speak with the defendant. He has not done his due diligence in checking the defendant's records, speaking with the defendant's family members or friends, and due to the fact that he's had the discovery since December 17th, it was on, quote, holiday and in South Africa for a majority of the time thereafter, he has not even had enough time to adequately go through discovery and make any type of finding such as this in this case. So we do object to this witness being qualified as an expert.
I do think that there's some standard, obviously, for letting an expert testify. I think that whether or not some specialized knowledge might be helpful to the finder that in this particular case. He seems like perhaps he hasn't had the depth of experience that other experts have testified. Whether I don't think he has that yet. I don't think there's anything that's disqualifying as far as the weight that should be given to his opinion. That's certainly something we can talk about. But as far as against qualifications are concerned, as far as him being able to give an opinion, again, we're doing all this for the record. His testimony's already been deemed to be inadmissible, but I want the record to be complete. As much information as possible about Dr. Lewis. So we'll recognize this witness as an expert in forensic psychology. I'm just watching things.
Before proceeding, Your Honor, I just want to clarify for my questions. Is the court finding that there was a violation of Rule 12 or 16?
No, I'm not finding there was a violation in the sense that a deadline was missed. I do think that, if you want to clarify my ruling, there are actually two aspects to it. The first is that it's clear that this expert's services for this purpose, for what we're talking about today, the defense felt it became necessary after a recent hearing last month where the monster exhibit was admitted, and there was some concerns about that as well as the medical examiner's testimony going to premeditation. So I think that based on the timing, so the state's not unfairly surprised, the workaround that the court is crafting removes the major, not the only reason that this witness's testimony on this issue was represented to this court was needed. So that's one of the reasons being excluded is that the state, I want to avoid the unfair surprise that Rule 12.2 contemplates, as well as give the defense a fair shake as he described in voir dire last week. So that's one of the reasons. The other is that I don't think that the opinion as written qualifies something that would be substantially helpful to the jury. When Dr. Lewis wrote that it's highly unlikely that Mr. Chen possessed the requisite premeditation, I find that there's a degree of speculation that it's not going to rise to the level where his opinion would be helpful. And also, I guess I could point out now that during Dr. Lewis's testimony moments ago, he talked about the great weight that he gave to personality profile type. And it's pretty clear in case law that personality type is not something that's even relevant to the defendant's capacity to form a mental state. That's pretty well established. So there are numerous reasons that this witness's testimony has been excluded from this particular trial at this particular point. Those are the reasons. Not a 12.2 violation. Again, I don't think there's any bad faith. I think this way the circumstances unfolded, I'm not finding that the defense acted unethically in any way. It's the way that it unfolded the short time frame. Yes, sir.
I'll need,
So it looks like, yeah.
I couldn't hear anything other than something with case law.
I really couldn't hear it either, but it sounded like they let him in
Yeah,
to give the
which they
defense.
should,
I heard
because
something like fair shake or something like that. He said.
yeah, he has the expertise that makes him a potential expert, but there will probably be limitations to what he can testify about.
Mhm.
Yeah, you're wrong. Start from scratch.
I wish they had remembered to put the sound on the other one.
Dr.
This
Lewis
was
noted
better
that
audio.
he had some technical difficulties about to let him in.
Looks like they have gotten it back, so let's go back and hear it over here instead.
and the top right corner it says, are
No, it's either video call or the
Can I try to work around it? Unless the state's gonna object, I guess it doesn't matter. Dr. Lewis, I'm forwarding what you sent to my office as a curriculum vitae. It says Douglas E. Lewis, Jr., BSYD at the top, and the top right corner it says REB period 9.C4. Is this your CV?
Yes.
Iris, it's still opening pre-trial motions. It's we haven't gone anywhere further since you checked in 2 hours ago. It's the same expert.
Purposes of this hearing, the defense moves to enter the CV of Dr. Lewis into evidence as Exhibit 1.
yeah, for this hearing, not to go back to the one.
May I approach you?
Free to move on the floor.
This is the first CD you sent or the second CD?
Second.
Okay, my CD says revised 924 is the one.
I miss.
Dr. Lewis, I have it. Dr. Lewis, I have a letter here from Regina Lewis at the board administrator at the Board of Examiner in Psychology. It's dated December 17th. Was this letter given to you, authorizing you to practice law temporarily in Tennessee?
Practice law?
I'm sorry, practice forensic psychology.
The practice psychology, yes.
Defense moves to enter this as exhibit number 2. Dr. Lewis, I'm holding in my hand a 7-page report, or memorandum rather. It says, the Honorable Boyd and Patterson, the top, dated January 11, 2025. Is this your memorandum pertaining to expert testimony regarding Jason Chen?
Based on what you described, yes.
Defense moves to make this exhibit 3. All right, Dr. Lewis. I want to ask you about the methodology that you used in this assessment. What validated psychological tools did you employ in your assessments of Jason Chen?
The psychological tools that were valid and reliable are the TOBA, the TSI-2, and the PAI, broadly and well-known instruments.
Are there, if you had more time to spend with Jason, are there other tests that you would have performed?
No. I mean, certainly there are numerous tests that we have at our disposal, but I don't think that would be necessary. In fact, a lot of mental status at the time of the offense evaluations don't use testing at all because psychiatrists and psychologists perform. So a lot of times testing is not even used.
Are the methods that you use consistent with the guidelines recognized by professional organizations like the American Psychological Association?
Yes.
And you don't have to go through it, but are you able to cite research and case studies that support the evaluation analysis that you did on Mr. Chen's or Jason's psychological state?
Yes.
And is it relevant to premeditation?
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
Good job.
I wish this judge had this case.
Yes, Schonberg.
Directly relevant to the
Get
issue
that.
of patient, just like most legal questions, there's nothing that's directly low on any type of legal issue. However, those are tools, yes, that are used to answer some of the legal questions and controversies that emerge.
Do you believe that you were provided all the relevant materials, including evidence including evidence to ensure that your assessment is objective?
That is objective, yes, I strive for objectivity, but as I mentioned earlier, with the introduction of more information or data that's objective, my opinion could change. However, based on what was available to me, as I mentioned in the memorandum, that is how I form those are the bases of how I form my opinion.
In your opinion, you say when to a reasonable degree of psychological certainty. What does that mean in the context of your opinion?
That means just like in any type of psychological science or practice, it is highly likely that what I'm saying is correct. However, when it comes to behaviors, actions, etc., we cannot say definitively anything. So that is what that means. That says that means that given the resources that I've been given, also the evaluation, the psychological test, etc., that to the highest degree to which is possible as a psychologist or a psychiatrist, this is what my opinion means. However, we can't say anything definitively.
Well, that's my question is, why can't you say this, your opinion with certainty? Absolute certainty.
It is. I am certain of my opinion. However, to say absolutely certain, I would have had to be in the room when these things were occurring, which none of us were. So I can't say this is absolutely what happened. I cannot say that because none of us can say that. However, based on the information, the data, the testing, the evaluation, it is highly likely that the opinion that I reached is the accurate one.
Would you characterize your opinion as based on speculation?
No.
Why not?
Because I used and reviewed all the evidence that was in the discovery. I also conducted psychological testing. I reviewed his legal history, again, things that are in the documentation. So speculation alone, based on my understanding, would be not using any form of evidence, not trying to use any type of objective psychological testing that's both valid and reliable. Those type of things, I think, I would characterize as speculation. However, when you use a multi-method approach, as I did, I would not characterize my final conclusion as.
I'm not sure. Why can't they save this questioning for trial? We don't need to hear this now. Well, we actually do, because the judge have to rule if he is allowed to come in as an expert, which he probably is, and then he's gonna allow what part of his findings he can testify about. So he can't come in and testify and say, well, he's schizophrenic, because he didn't do an examination that could qualify him to have an opinion about schizophrenia. So this is the beauty and the backside of doing trial streaming, because the jury will not have to hear all of the nonsense that we don't hear. They'll have to hear a lot of it again, or a lot of it at trial. But this is actually so they don't have to sit through 45 objections from the state saying he can't testify about that, he can't testify about that. Then they'll have to have a sidebar. Then they'll have to have another voir dire on why he reached the conclusions he did. That's why they have to get all of that checked out right now. That's why if you were watching, and I know you were, the Can Read case, Dr. Russell was only allowed to testify in specific topics, even though she had expertise that could have made her testify on other subjects, but she was only allowed to testify in very specific areas. That's why you have these hearings before an expert is put on the stand.
Speculative.
Did you make any assumptions that was unsupported by the evidence informing your conclusion?
No.
So can you explain to the
It's not hearsay if the defendant tells him, this is my experience. That's part of a normal hearing. It's not, but he will have to say it's self-reported.
court how your psychological insights from your evaluation into the mind of Jason Chen are relevant to the legal question of premeditation?
Okay, so premeditation is arguably something about one's mental status or mental state during the commission of an act. So just like any other mental status related evaluation, I am assessing and evaluating not only what came before, during, and after the act, but also I'm also looking at the personality profile of the individual. So I'm using all those things in order to answer the legal question. Typically, again, when it comes to legal questions like competency to stand trial, like mental status at the time of the offense, violence risk, etc., there's no legal question that psychologists or psychiatrists can directly answer in the way that you all are trying to characterize. What we do is we use all the information that we have available, data, interviewing, observations, testing, etc., to answer the legal question. But it's not like A plus B equals C. That is not how these things work. Like, for example, there's no real test of premeditation. There's no test of mental status at the time of the event. We use the information that we have in the testing and the level of questioning and training that we have to make to give the court answers to its controversies.
So sticking with the premeditation, particularly in cases with premeditation or where you're dealing with intent, can you elaborate on the specific experience conducting those types of forensic evaluations?
So those type of, like, I actually am in the middle of one. I have one that I'm doing that has to do with the intent or the case element of intent in Virginia. And in those type of cases, we're looking at one's functioning, behaviorally, socially, and intellectually or cognitively in order to make determinations about one's intent. For example, it was posed earlier about his reasoning and critical thinking. If someone, for example, has an IQ of less than 65 or less than 60, there's certain types of crimes without the assistance of another person, you know that they would not be able to do because they don't have the level of forethought or thinking. In terms, that's an easy way of kind of understanding it. IQ or functioning in terms of their cognitive functioning is something where we would be able to answer that type of question.
So can you explain your role as a forensic psychologist and how it's distinct from a psychiatrist or a general clinical psychologist in assessing premeditation or intent?
A forensic psychologist is a clinical psychologist who has specialized or specialty training in forensic psychology, meaning we have gotten some type of legal training and that we understand how to understand and know how to interpret certain statutes, and we also apply psychological principles to legal issues. For example, as I mentioned before, the idea of competency to stand trial, mental status at the time of the offense, these are legal issues. However, you need a psychologist or someone with that particular training in order to answer those questions. So we're different from a forensic psychologist, different from a psychiatrist, because a psychiatrist cannot issue testing. Usually their training in forensic is not as comprehensive as it is when you are studying to be a forensic psychologist. And we're definitely different from a general practitioner because general practitioners are there to treat and evaluate mental disorders only. They don't have the legal piece, the legal understanding. For example, I had 2 to 3 years of didactic instruction about cases that involve mental health or psychological issues.
What methods did you employ in forming your conclusion about Jason Chen's mental state at the time of the offense?
I reviewed the entire discovery that was made available to me. I interviewed Mr. Chen extensively, not just questions about his personal history, but also violence risk and also sexual violence risk. Again, those questions were not all face valid, meaning there were times where an examinee would not know why I was asking the questions that I was asking. I also administered 3 psychological tests that are both deemed valid and reliable within our field.
So in regards to the assessments that you did on Jason,
Make them more.
let me start over. The question is whether, right here, let me say this. Can you explain the psychological concepts of emotional regulation, impulsivity, and how they're relevant to this case?
So emotional regulation and impulsivity are important to this case because often people who commit murder or other heinous acts of violence, it tends to be in a heightened state or what I call affective aggression or violence. So someone who has trouble regulating their emotions, or someone who is quick to anger and also is impulsive, they are likely to engage in behavior without thinking. And a lot of times, our jails and our prisons are filled with people who have committed acts out of being angered, not thinking, impulsive. So emotional regulation and impulsivity are two, in my opinion, major factors in most crimes when it comes to aggression and violence.
So one of the tests you did was, is it called TOBRA? How do you pronounce it?
It's called the TOBRA.
And you conducted the TOBRA with Jason Chen?
Yeah.
How did his performance in this test form your understanding?
This is in Chattanooga, so it's Eastern Standard Time.
His cognitive capacity for playing the role.
Well, the reason why I issued that test is because someone who is highly intelligent will create a different type or make slightly change the way that we characterize in terms of the profile. Because so I needed to know where he failed in terms of the fail curve, in terms of intelligence. So it's not a test of intelligence, but one of reasoning and critical thinking. And so if he is scored really high on there, that may have informed me in a different kind of way about how he's functioning in terms of, his proclivity perhaps for manipulation, deception, lying, etc. And so I need to know where he failed. And so I know that he falls in the average range on the fail curve in terms of, reasoning and critical thinking.
Is your opinion inclusion based solely on that personality test?
It is based, that is a test of reasoning and critical thinking, and no, it is not based solely on that. No opinion should be formed based on one thing. It needs to be a multi-method approach.
In the TSI-2, you noted Jason had anxious arousal and intrusive experiences. How do these findings support the conclusion that Jason's actions were likely?
What's that? Is that
What do you say?
He had anxious arousal. Is that if you're afraid of someone, you get a stiffy?
Anxious arousal. I don't know. Did you say stiffy?
That would be like every time you yell at me in private chat, my table did this.
Baker said stiffy.
I don't. Thank you, Brendan.
In terms of supporting it, it basically builds a profile of how he's functioning. This is someone who likely has bad memories about something that has happened to them, experiences anxiety, which is worry or restlessness. Individuals like that may be quick to agitation. They may engage in behaviors to reduce tension, like using marijuana or alcohol. This is developing a profile of how this person is functioning daily.
How does your reliance on the empirical testing, using those the tests that you did, and I guess the evidence and discovery that you received, ensure that your conclusions are not speculative?
It strongly ensures it because best practices indicate by the specialty guidelines of forensic psychology, which were adopted by the American Psychological Association in 2013, indicate that we should engage in a multi-method approach when it comes to evaluation assessment. And therefore, based on that adoption of those specialty guidelines, based on my work in the field of mental health since 2010, my work with inmates or justice involved individuals since 2014 or 2015, it ensures me and informs me that my opinion is not speculative.
Were your findings consistent with other peer-reviewed literature and established psychological principles?
My findings were consistent. Let me answer that in a different kind of way. The approach and the procedures that I used were consistent with any type of empirical research, for example, etc. My finding or my opinion is something that I reached based on using those methods that were consistent with all empirical research that's available.
Were the methods that you used, the forms that you used, were those reliable?
Yes, those tests and or forms, however you want to refer to it, have been used for years by psychologists across the nation. You can easily Google them and you can learn about a lot of these tests. And these testing are well developed. In particular, the personality testing score was developed by Dr. Leslie Moray at the University of Texas, and he's still doing research on that testing. So it is very reliable.
Is it that your findings and conclusions that Jason Chen couldn't have formed the requisite mental state premeditation? Is that your opinion?
My opinion that it's highly unlikely that he formed the requisite premeditation.
Questions? Is yours ready for lunch? Yes, sir. The jurors walk by, everyone's done. One more question?
Would any reputable forensic psychologist say with absolute certainty that a subject had the requisite premeditation or requisite intent, or is that something that goes too far beyond an opinion?
Saying absolutely certain is going too far beyond opinion. No reputable forensic psychologist or forensic psychiatrist should say anything with absolute.
Thank you.
Come on, gentlemen. You can send the jurors along. Council protocol 2.
So are we going to lunch now?
We haven't even gotten to the trial. I'm gonna have to go before the trial even starts.
Come on, step off. Can you hear me now?
Yeah.
Dr. Lewis, thank you so much. Mr. Watts will get in touch with you shortly to let you know how to proceed, how we're going to proceed in this case. I do thank you for your time this morning. Okay?
Absolutely. Thank you. It's a privilege.
So the jurors consent to lunch. They've got 50 gallons in the jury room, which means it won't take them very long. So give them a little time to walk around. It's supposed to be our lunch break too. Are there any matters you want to take up before we take our lunch break?
Yes, there are two separate issues. One has to do with the indictment. The state has indicted Mr. Chen for abuse of corpse. In that indictment, we listed all of the factors under the abuse of corpse statute, two of which inarguably do not apply and would be prejudicial if they were read to the jury. One of those is disentering a corpse that has been buried or otherwise interred. The other is the other one is engaging in sexual contact. Neither of those are being argued by the state, so I would just request that I be able to leave those out when I read the indictment and only read the other two subsections that could apply in fairness to Mr. Chen.
Okay.
And then the other judge, so that the defense can object before opening statement, the state intends to introduce the suitcase that Ms. Pace's body was in during opening statement to avoid delay during opening statement where the jury has to go out. We figured we'd go ahead and disclose that one.
So you want to show the suitcase?
Yes, Your Honor.
Okay. Why is this common for evidence that's likely going to be admitted to be used in opening the objection?
Thank
Well,
you.
to the extent of all my past motions to suppress all those.
Not waiving anything.
Thank you, Judge.
All right, that clock says 12:20. Everyone will be back when that clock says 1:15. That's 55 minutes of lunch. What we're going to do is start the trial register in. Instructions.
I will set up the stream for.
I go into lunch then.
Yeah, they'll be back at 1:15, so we'll be back at 1:05, 1:10. I'm gonna set it at 1:10 so Brandon doesn't yell at me. He's been really
Mhm.
after losing mod of the year last year. He's upped his game and really doing like the rest of the mods. Yells at me a lot. But we had a poll that we need to finish because, like Valhalla, I started out thinking she's kind of yelly, this lady. But
She has her moments, but she's growing on me.
yeah, I like her. I think she'll be good. I hope she's not going to be very condescending. Like I didn't like that your school, online school, but it's actually almost a three-way split. First impression, prosecutor. 37% says whiny, 31% says strong. Jamie is a hater, 31%. So
I am.
I grew to like her. So
Yeah, I mean, sometimes some of her stuff that she's been doing, like, it doesn't bother me. It's just when she gets like super yelly and whiny, but she's growing on me.
yeah. Yeah, you had a Fuji apple chicken salad. I will be having some soup and garlic bread because I need that. It's cold here today. So someone had pho. I
Soup.
never had pho. I don't know what that is, but I've heard about it. Never had much Chinese food. Um,
You never really had Chinese food?
no, that's not really that big. If Chinese food in Denmark is mostly, like Mongolian barbecue, where you can get some buffet and stuff like that. And you know what you say? Buffet is just sharing germs.
I like Chinese buffet. That's what you should have got, Baker, is some good old Chinese food from the Americas.
Yeah, send it
It's
over here.
just
That'll
sugar
be.
chicken and deep fried cream cheese. They call crab rangoons.
Oh, pho is Vietnamese. Still, I haven't had. I actually went to. We had a big influx of refugees when I went to school. I know it was some years after the kerfuffle in Vietnam, but I remember we had maybe in fourth or fifth grade we had a big because that was just when refugees from all over the world kind of started coming to Denmark. Had a big day where they came and made their home the country's specialty. And I remember one lady made Vietnamese spring rolls. They were amazing. I remember them to this day. So yeah, Daloon. This is a spring roll factory half an hour from where I live. I like mango grill. Oh, is Vietnamese. What kind of soup? Just some beef soup with some vegetables and some meatballs and flour balls.
Hmm.
You actually should in Newark or Philly or whatever you're going. The Chinese food is good in that part of the country. Yeah, I'm looking at it. I think I'll be doing the flying into Newark. It makes the most sense financially, but then I have to figure out where to stay when I go on my round trip. That's that's going to be a little bit harder. What time are you back? Your time? I'm only a hour behind you. Sinead will be back at 6:10. 18:10. Sounds yummy in the tummy.
Hmm.
Well, I don't want to go to New York City. They have congestion tax. We had a government try to suggest we should have that in Copenhagen, and everyone said, "Are you crazy? That'll ruin everything." So you went before us. You're about an hour away from Newark. It's not that far from Newark to Philadelphia. I looked at the map. It's like this. I can do that in a split second. But no, I think that's going to be the thing that's the easiest. And then everyone say, oh, you should go to Massachusetts. But then that's up, and then I have to go back down and go across and go down. That's probably, it's easier to just go to Massachusetts, find somewhere in Ohio where people can meet up, and somewhere near Jamie. It'll probably be in front of Jamie's house while she yells at us from her house. And
Yeah, stay out.
yeah, well, I'm gonna miss your driveway anyway because you can't even find it.
Well, I bet you $200 that you'll pass it by.
No, because I'll be using the GPS and it'll tell me coming up on your right.
Whatever. Well, you can't always
Hey, what
rely
do
on
you-
that thing.
Especially when you're yapping your head off and Iris is sitting next to you and saying, "Oh, that one time
And
in
it was
cartel
dark
camp."
also. At cartel camp.
Yeah, I can make California off your list. Stopped at the Colorado mountains. I wouldn't be going to California anyway. That's too far to drive. That's I saw someone got a massive bill because the free mileage you get when you rent a car apparently isn't free. So I have to make sure it isn't. So have to figure that one out. Yeah, Jamie is the grandma.
Listen, I am Ginger. Also, I always put on GPS everywhere I go, but Iris knows that sometimes I listen to it, sometimes I don't. It's telling me to turn, and I'm like, nah.
Yeah, I looked at the map and it said Philly was roughly 1.5 hours away from Newark. So that's why I'm saying we could do because the plane I'm looking at flies in at around 2 in the afternoon. So we could do a meetup in Philly on the first night. Then I can drive on the next day to somewhere in Ohio and do a meetup there. That should be like 4 or 5 hours driving. And then I can go up to Jamie. That's another 4 or 5 hours driving, I think. Well, the problem about JFK is you have to go through New York. It's a heck of a travel. But if I fly into Philly, I have to pay 2,000 Danish more than if I fly into Newark. And renting a car for a week is 5,000 Danish. So that's half the car payment I have to pay. PA is a huge state. Well,
Yeah.
I don't. I looked. I did do the Newark to Philadelphia, Philadelphia to Ohio, Ohio to Detroit, because I know Jamie lives somewhere near Detroit. So I have put the numbers into the goggle, and I think I can do it in one day. Find a hotel, meet some people, drive the next day. I think it should be possible. I'll probably be on a lot of ibuprofen, but that's what I have to do to meet up with people, and I think like 6 hours to a hire from Philly. Well, I can do it in 6 hours. It's not that big of a problem. If I go at 10 in the morning, I can meet people at 7 and go to bed at 9 again.
I don't know how you do it.
Yeah, but I need a car to get around because I will have to go down to. The only problem I have is I'll have to fly out of Newark again. So, and that's a 10-hour drive from Tennessee to Newark. So probably need to find somewhere to stop in on the way up, maybe in Virginia or DC or something like that.
Stay in these states. Your little accent. I'm like, what's he talking about? Did you say Virginia?
Yeah, Virginia.
Virginia? Okay. I got it. I got you.
What are these approximate dates? They are the first week of June. I'm thinking about flying in around the 29th or the 30th of May and flying home the 8th or 9th of June. Flying into Miami would be really, really dumb because then I'll have to drive all the way up and across and down again. So, yeah. Columbus, Ohio. The problem is we don't have direct flights to there, so I would have to change planes, and that's when it gets expensive. We do have direct flights to Philly, but it doesn't really make sense. But if I fly to Columbus, Ohio, I would still have to go back to say hey to Marissa and the people who want to see me over in that part of the country. Probably if Brandon isn't too drunk that day, I could go meet him at a golf course and drive his golf buggy around while he yells at me and make me feel at home.
Hmm.
Thank you so much, Jeanette, for my holiday fund.
That's sweet.
Yeah. Well, I would love to meet as many as possible in public places so I don't get stabulated by Iris.
Well, me and Iris are already coming to you, so
Yeah, she's gonna
she's
stab
gonna
me
get
in
that
Denmark.
chance. Well, I mean, she'll get less time.
No, the good thing is our healthcare is cheaper. So when she stabulates me, and I can get back on my feet till June.
Yeah.
Trying to pack a lot into 4 hours of your first day. Hey, anything worth doing, I can do in 30 seconds. Jamie, don't think about it while we're on break. See you all later.
Okay.
Exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100. Because it is 100% correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody